I told you you should keep your pins not outside. One.
My Lordship, I request you to permit me to withdraw the
Correct. That's what we were required.
No,
we would
the
have told
liberty.
you.
The
Liberty to what? Move an
to
application
re-
before the court, commercial court.
Yes, sir.
Give the file.
Resubmit it again before the High Court, Your
Resubmit.
Lordship. There is actually some change in the facts and the circumstances, so I would
You with the liberty to file an application under Order 39, Rule 4 of the CPC, correct?
yes, my lord.
Even otherwise, it's an ad interim order. File matter. Item 1. Mark the presence. This appeal under section 13 within bracket 1A of the Commercial Court has been filed. Commercial Court Act has been filed against an order dated 15/3/20. This is what I want. Against order dated 15/3/2023, passed on an application under Order 39, Rule 3 of the Code of Civil Procedure. Paragraph: Learned Counsel for the appellant submits that in view of subsequent events, the appellant be permitted to move an application under Order 39, Rule 4 of the Code of Civil Procedure and be permitted to withdraw the appeal. Paragraph: in view of aforesaid submission, appeal is dismissed as appeal is disposed of with liberty as aforesaid. This is this you could not mentioning. Yes. Next. Next. Yes.
Your Lordship's item number 42 in this matter, I'm appearing for the appellants, Your Lordship. IA 1 of 23 has been filed for modification of IA 2. I'm requesting 2 weeks' time for filing counter in the matter.
Who appears?
I appear for the respondent in this matter, my lord. Matter may be taken up today, my lord. There's an urgency. There are 2 applications pending today.
It's coming up for the first time. We've already sent the counter for signatures, Your Lordship.
This
Not 2 weeks, madam, 1 week.
One.
I once.
Okay.
You are appellant, madam.
I'm the
42. Learned counsel for the appellant. Praise fund is granted a week's time to enable her to file reply.
File counters
Counter.
in IA 1
Counter to IA 1 of 23.
as well as IA 3 of 22, Your Lordship.
IA 3 of 2022.
And IA 3 of 2022. 1 of 23 and 3 of 22. Date. 14th August.
Much obliged.
Item 46. Your lordship's kind permission. Item 46, my lord. I'm appearing for the petitioner counsel. Requesting for a week's time, my lord. Already informed.
do what? No, vacate stay petition is there. We won't adjourn at 10:30. In case of vacating stay, we will take it up. It will be called.
In this matter, I appear for the R9, respond number 9. Even I have to file a counter in this matter.
No, you have filed vacate stay petition.
No, I did against.
And then his opinion matters. You tell him. If he has no objection, we will adjourn. No, you tell. He called, he did not call. You objection to prayer for adjournment. 46. 46.
Yes.
What's your name? Mark their presence. Learned counsel for the petitioner submits that the arguing counsel is unwell. He therefore seeks for adjournment. The aforesaid prayer has not been opposed by learned counsel for respondents. List after week. Yes.
Obliged.
Yes.
I may be permitted to make mention, my lord.
Yes. You want the matter to be listed today?
Today,
What's the urgency?
urgency, the medical farming admission, MBBS admission,
All right.
they are fine.
Yeah, today.
My lordship, may I please, my lordship? My lordship,
Ah.
batch of petitions regarding enrollment at the bar council, my lordship.
Ah.
Actually, the AIB exam is expected to be scheduled next month.
Expected to be scheduled.
No, you should.
Yeah. Yeah. Day after.
My lords,
10th August. Mr. 10th August.
my lords, may I make a mention, my lords? In today's list of item 58 to 61, there is a connected matter which we filed and numbered on Friday itself. My humble request is your lordship may kindly take that matter also.
58 to 62 is a batch.
There is a batch 58 to 61. My case is
62
also
or
on the same list, my lords.
62.
It's not listed.
No, we have come across many cases where lawyers have got tagged the case with a case with which nothing to do with each other, different subject matter. We hope you are sure about what.
And I am sure about it. It challenges section 10A of the 1994 Act pertaining to regularization of contract employees. It's the same list, my lords. I filed same challenge the same statutory provision. That GO, yes, my
Employees have been regularized contrary to this thing, right?
Uma Devi's judgment. Yes, my lords.
And in those petitions, petitioners have not implemented the affected persons. We hope that you have done so.
We have implemented some of them in their representative capacity with
Yes.
the prayer to your
Ah,
lordship
then.
to
All right, get it.
this may be taken up with 58.
Yes, 58.
Subject to your lordship, can leave, my lord.
Ah.
I mean, permitted to make mention, my lord. It's a matter where WPTR 617 of 2017, my lord. Here it's a matter of recruitment, my lord. It's a recruitment of child development project officer. Lordship has heard this matter. It's covered by the judgment of Honorable Supreme Court, my lord. Lord, it's a
Please file an application seeking final disposal in the light of the judgment of Honorable Supreme Court. We will decide.
my lord, the urgency is that, my lord, it has been
All by way of this mentioned memo, do file an application for disposal of the petition.
my lord, already filed, my lord.
Give a copy to the other side so that he knows what judgment you are relying upon.
My lord, already given her the other bench of lordship sitting with along with Justice Vinod.
Similar matters are there. Who is appearing for the state? Similar matters are there on the board today. I do not remember which are the numbers, but there are matters.
No, but is it whether any interlocutory application is pending or you want final hearing?
Well, final hearing, my lord.
Final hearing we don't grant by mention memo. That's the rule firmly
It was
established.
listed earlier.
Please file an application for early hearing. This bench has not heard and nothing has been done. We have not reserved your case and not delivering judgment, right?
My lord, it's not.
It will never happen in this court that the judgment is this thing reserved and it not delivered.
Not reserved, my lord. It was heard, my lord, but
I don't know. I don't know. I have never, at least speaking for myself, I have not heard
it
it.
was there in the list, but it could not be reached, my lord. That's only it.
Let us permitted to make a mention, Millet. We have filed Millet an interlocutory application in a pending writ petition, Millet, which was Millet above.
What is the urgency?
Millet urgency is that Millet there was an interim order that was in operation. But
That
it
has expired.
could not be Millet extended for
Tomorrow.
tomorrow.
Yes.
Yes, mine is also
Huh?
one same. One more repetition.
Interim order not extended
Not extended.
tomorrow. Yes.
My lord, the commercial court opinion had come up on Tuesday before this honorable bench, my lords. My lords,
Applications will come under interlocutory, heading interlocutory.
Interlocutory act.
Those will come under interlocutory.
Yes.
my lords, the commercial court opinion had come up before this honorable court on Tuesday, my lords. However, my lords was pleased to grant a direction directing the matter to be listed before another bench, my lords, on Friday. However, the matter is not come up, my lords.
Then how can you make a mention before the same bench matter?
To move, you will have to move the registrar judicial on administrative side. He will put up a note before.
Best thing is to ask the court, right? Ask court anything. We answer. What should
I
you do?
apologize.
You should inquire from your senior, madam. If you don't know, please feel free. All these people are your colleagues. You ask them that the bench has recused. Should I mention before the same bench or what should I do? They would anyone, the person sitting to you would have told you that, madam, you need to move. Don't ask the court. We are not supposed to answer.
I'll mention now, take the needful steps.
Don't do it.
Yeah.
Don't, this is not the forum to ask questions to the court. What should I do?
I apologize.
Lordships, I beg to mention the lunch motion in CRP 2301 of 2023. On Friday, we made a mention before this court and we got slip and it is not listed in today.
Why? We will look into it.
There is a pressure from the court lawyer for insisting cross-examination wherein the WhatsApp documents were filed.
Nothing, cross-examination.
Not this one. Family court matter. This is not before this
No.
court.
Lordship, actually it regularly comes with CRP, but what we are asking is a stay petition, IA, but there is
no.
already, there is an order. There is an order.
You talk to registrar judicial. This is not a matter in our jurisdiction, right? That's why it is not listed.
There is already
No,
an order
if
of
you-
single bench.
No, supposing if you obtain a mention memo in respect of a petition under section 438, it will not, won't be listed before the court. Then you will say that I had mentioned memo because the judge, honorable judge dealing with 438 and 439 alone can entertain.
But
So
Lordship,
same like that young girl you are also doing, what should I do?
Lordship,
Senior counsel, they are sitting, what should you do?
yes, Lordship, there is already an order in
Nothing.
respect of the same FCOP to dispose it within 3 months. Now, when we are asking for a stay, the single bench order is already there. That's why we are seeking the permission of this court.
Mister, you make a statement that this matter is within the jurisdiction of this court. We will record it. And if it is not so, not only your petition will be dismissed, but costs and everything else for making a misleading false statement before the court. We are putting you with full sense of responsibility. We have put you to notice. Brother has said, I have told you that it is not the matter within our jurisdiction, despite that you are insisting. We told you, ask the registrar judicial, go and meet him. Not ready. Make a statement. This is whatever transpires here is a serious business.
I apologize.
Don't.
Apologize.
If we are telling again and again, if you don't know, say don't know. Don't make deliberately the false statement. The consequences will ensue.
Apologize.
Next. Yes.
My lords, I beg to appear in this matter. My lords, this is a
This is 39.3.
fine, my lords, against the orders of the commercial court in a patent infringement matter.
39.3.
No,
Order on 39.3. You are yet to, have you received the notice?
yes, I have received.
Have
the-
you appeared?
My lords, I filed a wakalat from the lower court. I have
Well.
received the notice. In fact, the matter is listed today, my lords, later in the afternoon. My lord, but my
No. What we would advise, we are ready to, we are bound in law to hear you. But your experience would tell you that in a matter challenging an order under order 39 rule 3 and ex parte order, when you have received notice, it's better that you file reply and we direct the commercial court to decide it within a time bound manner after hearing both the parties. That is one course open. Another course is that you press this appeal, we hear you and decide the matter on merits. In that case, it can go in your favor, it can go against you, we don't know. So choice is yours.
my lords, may make a
We would suggest the second option, that you file reply and we direct the commercial court. It's an ex parte order 39.3. Appear, file reply, commercial court will hear arguments of both sides and we can say that in a time bound manner, it shall
My
decide.
lords,
In terms of too much.
Yes,
my lords, a reply would be given in the lower court, but my lords.
but you want to argue.
Yeah.
Fine, yes.
My lords, the matter.
Then we will decide it on merits then, right? You are arguing, then don't say later on, I want to withdraw.
Yes.
Ah.
Obviously. My lords, the
1 minute.
appeal is filed on the orders passed by the lower court. My lords, in a alleged infringement of a particular patent. My lords, the
Give us 2 minutes.
notes. My lords, the 3 points, my lords.
Application. Yes, please.
My lords,
Yes. What was the suit filed?
my lord, suit was filed for infringement of a particular patent. My lords, a drug patent. My lord, that's the allegation that is leveled against me.
Suit filed for infringement of
A patent, my lords.
when it was filed, date.
My lords, the suit, I'm not aware when it was filed, but my lords, the order was served on us on 25/7.
Which order?
The
Ex
order
parte order.
dated. The lower,
When did you file the suit?
It was filed on 24th,
24th July.
23rd, 24th, 24th July.
24th July.
The order
Along with an application under order 39
39, 1 and 2.
1 and 2 and 39 3.
No, my lord, only 39, 1.
39 1
And under section 12A also.
and 12. So the court has granted an order on 25/7 ex parte.
That's right.
Yes. Yes, please.
my lords, it served on us on 28th.
Ah.
My lords, I tried to move a lunch motion on Friday, my lord, but lordship said, let the matter come up on Monday.
Yes.
My lords, my argument on this is threefold. I'll just sum up my argument, then I.
Yes.
My lords, the first point is, my lords, that lack of prima facie case, which is placed on record by the plaintiffs. My lords, the prima facie, they lack a prima facie case. My lords, the lower court goes ahead, gives an injunction saying there is a prima facie case. But my lords,
You say no prima facie.
no prima facie
All
case.
right. No balance of convenience, no irreparable injury. 3 grounds presumably.
Then, my lords, for me, there is a irreparable injury that is
Ah.
happened. Even
So
as
that's
I'm-
what you would say, no irreparable loss and no balance of convenience in favor of plaintiff.
yes, my lord.
Correct.
My
These
lord,
are the
even
grounds.
even as I'm arguing this matter,
Ah.
an irreparable injury is being caused to me.
Ah.
Then, my lords, the second important aspect is, my lord, there has been a gross misrepresentation and rather a blatant, my lord, I don't know whether I can use the word, but blatant lies by the respondent plaintiff before the lower court. In other words, my
That
lord,
is
they have
what you are
gone-
required to bring to the notice of the court. It's not a matter to be argued in High Court
No.
against an ex parte
Yes,
law.
yes, yes.
We don't know, Mr. If we express all this, that there is a prima facie case, balance of convenience, you are arguing. What happens to 39(1)(2)?
My lords, I'll ask myself one question.
Yes.
In a matter of a patent, which is completely
All right.
techno-legal,
Yes. So, what gross misrepresentation about what? Facts.
two important points, my lords.
First is you said.
There is
lack
an
of-
allegation that I'm infringing an existing patent.
No, gross misrepresentation about what we want to understand.
Two, that's what I'm saying.
Yes.
Two points.
Hmm.
One, my lords, that I'm infringing an existing patent while I'm not.
Hmm.
The second was, my lords, the misrepresentation was a construction and the case was set up based on their assumption that I am infringing. Their
What was set up?
assumption that I am infringing the patent.
Huh.
My lords, no single technical document is filed before the court, nor any document showing that an infringement is happening has been filed.
Hmm.
My lords, and they deliberately mislead the court on earlier provision. That is, my lords, non-compliance to the provisions of the Commercial Codes Act, more specifically 12A.
12.
My
So you
lords,
say
what
that no urgent relief is involved, therefore 12A applies.
they,
Yes.
my lords, they actually make a representation saying there is an urgency. But the
No,
factual
no
position
urgency.
is-
No urgency.
My lords, how is it that there is no urgency, something that I would like to urge before this court.
Yes.
One, my lords, two sets of caveats were filed by me. My lords, 180 days lapsed. My lords, obviously it seems to have lapsed on 23/7. And immediately the next day, the suit is filed.
What did you say, please?
My lords, I had filed two sets of caveats.
Uh,
My lords, they lapsed on a particular day.
yeah.
2 days later, the suit is filed.
180 days suit has been filed after 2
Yes,
days.
ma'am. My lords, the caveats expired in June. My lords, then I have been manufacturing the product from January. It is recorded in their plaint,
January what?
January 23,
2020.
2023.
Here is
Because
it.
that particular patent, my lords, expired in January 23. Yes, sir.
Yes.
16. My lords, I'm told the patent expired on 16th December 2022. And when was December? I stand corrected, my lords. It expired in January 2023. Well, the lordship knows once a patent expires, it gets into the public domain. Anyone can commercially exploit. My lords, my product that I am manufacturing today falls under the expired patent, not under the patent that is being alleged to be live. Therefore, this infringement arose. My lords, with regard to the first limb of contention which I raised, lack of prima facie case. My lords, how did the prima facie case arise before the lower court? My lords, my contention is this. My lords, a patent is a techno-legal document. It consists of technical aspects as well as the legal aspects. My lords, here it is a pharmaceutical product. Now, my lords, the entire judgment, the lower court order is given on a presumption, my lords. I am using the word presumption. Constructed by the plaintiff. The plaintiff erects a case before the court saying that they have infringed a patent that is live. While my contention, my lords, is I have not infringed the patent and the product I am manufacturing falls in the patent that got expired in January 2023. My lords, their prima facie case is not supported. My lords, it is not supported by any technical evidence. My lord, generally, what is done, my lords, an expert opinion is filed saying, yes, this is the combination of this drug and this is the combination of the infringing drug. So, since both are same, there is no such technical expert opinion is filed. My lords, in their own plaint, they say there is a process to analyze this and tell whether a patent is infringed or not. They don't adopt that. My lords, there is something called an X-ray lab report where it is analyzed, and then they say whether both the combinations of molecules or whatever it is the same. My lords, that is not done. So, my lords, insofar as the prima facie case is concerned, my lords, an entirely wrong presumption has been put forth before the lower court. My lords, and the lower court says they have established a prima facie case. My lords, the question is, my lords, establishing a prima facie case in a patent matter needs a trial. What is a infringement that has happened. My lord, unlike other intellectual property like trademark or copyright, where the infringed mark insofar as trademark is concerned, or the proprietary mark can be compared and then my lord's decision arrived at. Or with regard to the copyright, where the content of both the parties can be looked at and then a decision arrived at. My lords, in patent matters, it needs a technical backup. There has to be a expert opinion. None of them are presented. My lords, then Lords may kindly take the list of documents which are filed.
Yes,
My lords, I have filed the entire bunch of documents that my learned friend filed before the lower court.
you have not filed anything before lower court. Today you are
Not yet.
hearing.
No, not yet. Because my lord, I need a lot of technical input to even write the written statement. Or for that matter, if I am filing, my lords, seeking for revocation of the patent, even there I need lot of technical input. My lords, that is being done. In this
All
entire-
what you are arguing before us, you could very well argue before commercial court as well.
my lords, a
This
main
is-
reason.
You are, see, Mr., we appreciate your submissions, but it's not an appeal, it's not an order after hearing the parties. Had it been, we would have definitely appreciated, gone into whatever you are, still, yes. So, patent.
I would like to remove that doubt from your lord.
Technical backing.
I would like to remove that doubt and then I want to, my lords, clarify to your lordships why I approached this court.
No. So please tell us what is the scope of appeal against an order granting ex parte injunction?
My lords, because the ex parte order itself stopped the man.
The Supreme Court has dealt with this. Wander Limited versus
Yes.
India.
Yes. Water versus
Supplement
Anchor.
SCC 727.
My lords, while dealing with it, the Supreme Court also said. There is a note.
So, I mean, that is within the, you say that is, your case falls within the scope of that, right? The law laid down by Supreme Court that
My lords, even in
order is such a capricious order that this court exercising the power of appeal should set aside.
my lords, in Wander versus Antox, the defendant's product was already in the market. Same is the case with me. My product is already there in the market. My lords, it is not a case where I need to enter the market after, my lords, a particular time. No. I've already entered the market because I'm entitled to enter the market once the patent expires. My lords, in Wander versus Antox, my lord, while dealing with the case on hand, Supreme Court did take into consideration position that the defendant's products were also in the market. My lords, one major difference
Yes.
there, in that case, my lords,
Yes. So, yes, your product is already in market.
my lords, in Wander versus Antox, there was an existing patent. Here the patent has expired. Not only me, there are 22 other players in the market with the same drug.
One is enough, right? You are arguing on admission. One is enough. This, we are not hearing the appeal finally.
Matter of convenience,
Yeah. On so much bunch, I mean, it's, you are only on admission. Yes. Yes.
I just want my learned friend, I don't know whether he's aware,
Ah.
this order which is placed before your lordship was challenged before the Honorable Supreme Court.
I'll come to that.
And yes,
So I'll come to that.
that order, my lord, so therefore the Supreme Court actually entertained the suit, disposed of the suit, and said that the question of railway.
Supreme Court. I mean,
Yes.
what happened to this order then?
So,
You want to say challenge, so what happened there?
so by this order, the parties were
No,
sent
which
back.
order? He hasn't told us which
My
order.
learned friend,
I must my lords, the difficulty is, my lord, this preemption derails my thought process.
No. Please, let him conclude. Yes. Yes, please. Which page?
I have also enclosed the Supreme Court order. My lords, my lord, where my learned friend appeared, he appeared for,
Which judgment? Not sitting. PMP.
my lords, he appeared for ITC and I appeared for Tata Salt, Tata Consumers, where the question was relating to a packaging of salt. My lords, I challenged the lower court order on 12A. My lords, it did go to the Supreme Court. My lord, lordship will see the Supreme Court order. I have enclosed the same.
One minute. You must know what was the order passed by division bench. You haven't told us that.
Yes.
So we are
I know.
looking at by
So
ourselves.
because my learned friend immediately intervened, I had to.
Please don't, mister. Please do not let him complete. We will hear you.
sorry.
We also agree. We appreciate, Mr. Senior Counsel, that in any intervention derails the thought process. We also don't want lawyers to intervene when we dictate. So we agree fully with you. So what was, which page and what has been held by division bench?
My lords, I'll just give your lordship the gist of that judgment.
So just
Just
so
in two
12A, what you wanted to rely
Yes,
for
yes.
12A, what
Yes.
12A, what does it say?
My lords, there, the High Court held that the Amendment Act of 28 of 2018 is in the direction of legislative measures initiated and put in a place in the recent class clearly point out to a direction in which we are progressing towards resorting to mediation to resolve a dispute
Error of good.
as a mandatory prerequisite before taking recourse.
So not adverting to requirement of 12A is an error of jurisdiction. That is the ratio, correct?
Yes, ma'am. But what is the urgency that was put before it? It cannot be it cannot be a superfluous application
Yes.
filed and then argued saying I got urgency. No. There has to
You
be
are
a
saying
reason.
that it's an error of jurisdiction, that it has not satisfied itself, commercial court, with regard to requirement of 12A. That's it.
But if your lordship goes through the
What happened to this judgment in Supreme Court?
Supreme Court, I'll read the judge.
No, what happened? You tell.
Well, there what happened? Well, the issue arose between packaging of a particular consumer product. It went to the Supreme Court and the Supreme Court, my lords, they said, they advised both the parties to settle the matter outside the court. But, my lord, lordship will see at page 4, lordship got page 4. Learned counsel for the party state that since the appeal judgment raises some issues which would otherwise require consideration, we make it clear that we are leaving the question of law sought to be decided in the appeal proceedings, more so, in respect of interpretation of section 12A of the Commercial Courts Act, in the conspectus of the judgment of this court in Patil Automation Private Limited and others versus Rakheja Engineers Private Limited. The existing stock of the respondent as per old packaging is permitted to be disposed of within a period of 2 months.
Settlement arrived at. So disposed of in view of settlement arrived at between the parties.
Between the parties.
No,
Both the parties
adjudicate.
agree.
Fine.
There was some change in the color variation of the packaging. My lords, in view of this, my lords, this honorable court's bench judgment looks good. And in fact, this honorable court's bench judgment referred to all the judgments that pertain to 12A. My lords, all the judgments,
Yes. This is the. Oh, yes.
put it on page, it was in there. Page it went for four. My lords, this court, while dealing with that
So
aspect,
then, so the commercial court has not satisfied itself with regard to requirement of 12A, therefore order suffers from error of jurisdiction.
more particularly urgency, how does it arise
Ah.
when there were two caveats pending?
Hmm.
They were actually aware, I was in the market since January.
Yes.
My lords, my lords, I am a respected company. I respect the intellectual property of others. I have an intellectual property policy in place.
You should notice what how much time will you take more? 1 hour.
Yes.
Then we issue notice. Issue notice. Notice on behalf of respondent is accepted by so and so. Let him respond.
Mr. Ramkumar, we have this.
Learned counsel for.
We are not interfering with your defense before the court below. You can still continue that.
Learned counsel for how much time you want to respond to this prayer for IA? Learned counsel for respondent praise for is granted.
Whatever time your lordship can
A
give.
week's time to enable him to respond to IA 1 of 23, list thereof. Yes. Next.
Please.
Ah,
I am appearing for the department number 1 in this bill. Just 2 weeks time for counter.
ah. This is WA. Hey, madam, what are you doing? This. This. Oh, I should get this first. So at that time, no. Item 3. Yes. Yes, please.
I am appearing for the appellate.
Ah,
I am offering for the respondent number 1 below.
now,
To Lashma can grant 2 weeks time for counter below in the yes.
counter. This is WA. No counter.
Appeal, no counters.
Which provision of the
No,
this thing? The
in the counter IS below, that is seeking direction.
there is nothing, Mister. You read para 7. That is of the judgment passed by the order passed by learned single judge. How do you meet it? What counter?
Yes.
Huh? Yes, Mister. What did you say? All right. No counter. If you want to file reply to this suspension and direction, understand.
Yes.
No counter. How much time? Right.
2 weeks time.
Learned counsel for respondent praise fund is granted. So how do you meet para 7? What is wrong with this? Illegitimate children not entitled?
That's a ground, my lord, which has been, my lord, that come in the order, my lord, without there being a pleading to that extent, and it is not the case of the appellants also. That he is any illegitimate child.
Where is that?
My lord, if your lordship will please to take the order of the, my lord.
And it's an order of remand, right? You will be heard. He will also be heard. You can argue. He is not illegitimate child. He is not even the child.
My lord, that's an order, my lord, if your learned counsel wants to file his order, let him file it, my lord, in both the tribunals below, or my lord, so the authorities below, that was not his case, and that's not the case of the appellants also. Appellants do admit that he is the son of their own, my lord, their sister. They admit to that. They are never saying that he is any illegitimate child.
Then what has been done?
But
By the order, how it operates to your prejudice, that's what we want to ask.
That
The
is
matter has only been remitted. You will be heard, he will be heard. The respond number 4 shall decide Tehsildar by a speaking order within 3 months.
I just bring 2 facts to you.
So what,
My lord,
you tell us how.
One, my lord, the order was disposed of by this honorable court in 2023. Well, this order was disposed of.
Prejudice, it does not determine the order of the rights of the parties, nothing.
May I request?
You will have an opportunity to be heard. He will also be heard.
This, my lord, as your lordships are of the opinion that it is willing to file his counter, my lord,
No,
is
we-
wherein. Otherwise, my lord, I just
You-
speak.
You are asking for a stay. That's why we asked you, argue on admission. It is listed for admission, right? So then you, why bank upon it? We are asking.
Your lord. My lord, the writ petition was disposed of in 2023, 9/6/2023.
Ah.
My lord, by which time, my lord, this very same respondent, the writ petitioner, my lord, before the learned single
What is
judge,
the ground of
filed a
challenge?
suit.
One minute. You want the ground of challenge is number one, that he is not the illegitimate child.
That is not the case of the petitioners at all. My lord, that is a thing, my lord, which has been held by the learned single judge is our case. It is nobody's case that he is an illegitimate child.
No one's case.
Nobody's case.
How
Our
is-
case, not
No,
the
no.
appellant's case.
Right. So how learned judges come to the conclusion
And
is
that is the error which I would like to show to your lord.
out of record. Out of record, right?
No, my lord,
All right.
from the record itself, from the record itself.
You know, he has this, there is no material on record to arrive at a conclusion that he is an illegitimate child, despite that learned single judge held that he is an illegitimate child. What else? Second submission.
Is, my lord, 2023, my lord, this writ petition has been disposed of on 9/6/2023. By which time, my lord, the writ petitioner has already filed a civil suit OS 321 of 2022,
321, no?
321 of 2022. My lord, which he did not bring it to the notice of the learned single judge at the time of disposal of the writ petition. One other aspect. My lord, my
The
kindly-
OS for what?
But he filed a suit for declaration and injunction
Ah.
in respect of these very same property.
So what would respondent would be like he can't conflict, I think, like he's got the entry of the revenue record. So this order which may be passed by Tehsildar will be subject to outcome of OS filed by him. Tehsildar cannot confer any right on anybody, neither on you nor on him.
These are recording of rights, my lord, which was done, my lord, by an order of the Tehsildar on 7/4/2011.
Huh?
7/4/2011.
No, so it is like effecting a change in the revenue record, right? I am trying to understand.
It's done in 7/4/2011.
No. So therefore, entry in the revenue record does not confer any title or anyone.
We are not saying that.
Then
That we-
how then, and it will be subject to OS filed by him. We will make it subject to the OS filed by him. If he succeeds, then only this entry will be,
One thing,
if any entry is made in pursuance of the order, it will be subject to OS 321 filed by him.
these entries, my lord, I'll just.
What will happen? He will not alienate the property also, that we will also say.
The properties are, my lord, I did not.
Then
make
what
myself
happens,
clear.
Mr. He will, R4 will decide after hearing you. We are not held, he has a right, nobody is holding. He has a,
No, let me clarify, my lord. The
Yes.
appellants before your lordships are the sons of the original owner. That's the case, my lord. Their father died, they filed an application for succession. Succession was granted on 7/4/2011. My lord, it is the case of this respondent that he purchased it under, my lord, simple sale, my lord, from their father. In 1979, that is his case. My lord, he opposed the succession on the ground that he purchased it in 1979. My lord, may I kindly see the order that is passed by the revenue, my lord, the recording authority at page 45 for once. The appellants now before lordships are the sons of the original owner, Narsappa. My lord, this writ petitioner is the daughter's son. My lord, this case is that he purchased it. Your lordship, you please see the finding that is recorded by the recording authority at page 40.
daughter's son means whose daughter's son?
Original owner's daughter's.
Your father's daughter's son.
My lord, another wife's son.
Second wife.
Second wife's son.
Daughter. Second wife. Daughter.
Second wife.
Son of second wife, daughter. Second wife, daughter's son.
Daughters, exactly.
Second wife's daughter's son. All right. Yes.
So 45, my lord, will please to see for once.
He has purchased this land from the grandfather. Simple, simple. Nineteen seventy-nine with the same thing. That's what the 21. Those are been from probably dates of the. It's how three that's 16. What then we like. All right. Appeal is admitted for hearing. Respondents may file
You may request for a suspension.
let him file objections. We will counter to your IS. We will consider. We will consider that. What is the parties have been directed to maintain status quo. Nothing. You are protected, right? Nothing is happening.
I beg of it.
But this has to be done.
Right, Teachers.
I
yes.
beg to appear on behalf of the appellants, madam.
Let's, before the learned senior counsel commences, I would love to bring to Lordship's kind notice. Item number 23 is also connected. Blood.
23 are connected.
Yes, sir. So,
Both may be taken ahead together. So that's my request.
so is here. We will take 23. 23 who appears? Okay. Yes.
But just for the sake of convenience, madam, and the petitioners, the writ petition, I filed appeal, I can agree to the order. But even the 2 pages, I have only paper 6 dates, madam.
This is 23.
23. Yes.
Madam, Lordship, see serial number 2, madam. Madam, Sayana sold the property to the vendors or predecessor in title of the petitioners on 2nd April to 1975, where registered sale date of 1970. Madam, thereafter 3, 4, 5, 6 various hands changed, madam, by way of registered documents. Then your Lordship may come to serial number 9. Up to 8, so many sale deeds have been executed. Serial number 9. So one of the transferee enters into an AGPA with a realtor company called Radha Realtors. Serial number 9. Well, 10, they develop the entire area into a layout, including this land, and they sell it to various plot owners way back in 2004, 2005, 2006. Then your Lordship may come to serial number 13, madam. Serial number 13, when the layout amenities are not developed, the plot owners go to the consumer forum to get an order. That's serial number 13. Then when serial number 15, your Lordship notice.
So, I don't know if or something. Mr. Venkatesh, this is which area?
Madam,
Because I stay in one of these, this thing developed by this man, whether it is the same or something else.
I think it's different, madam. Your Lordship, I don't know where your Lordship exactly live, madam, but
I think it's much developed.
West End, West End Meadows. Layout is called as West End Meadows.
Yes.
I wanted to be sure.
Your Lordship gave us scared, again recusal, again
No,
something.
no, I wanted to be sure because if I am, the place where I am staying.
It's called as West End Meadows, madam.
No.
All right. Yes.
Then your Lordship may come to serial number 15, madam. After 48 years, the legal heirs of the vendor of 1970, they make an application to the revenue authority saying that without their knowledge and consent, the names have been changed in the year 2005.
They filed a revision under section 9.
Section 9. Section 9.
Against what order?
It is the order of a mutation of 2003, 2004, madam. 2005, rather, sorry, I'm sorry, 2005. Whereby, madam, a vendor's name was mutated in the revenue records. Now, madam, this was allowed, agreed by which, madam, serial number 17, madam. It was allowed by the additional collector, Rangari district. Agreed by that, the V plot owners filed a writ petition before the Honorable High Court that was dismissed. Well, agreed by this has come. Now, madam, 3 submissions. One, the learned single judge as well as additional collector, they take the contention of the respondents
saying that the vendor of 1970, 2nd April 1970, had expired on 26/5/1969. That is much before the date of execution. So this is one of the ground. Whether he died in 69, 70 or post execution is a disputed question of fact, which has to actually the civil court. After 48 years, clearly on the averment and a statement given, my lord, saying that when Sarpanch gives a death certificate.
Your vendor, when did it?
Vendors, 1970, person who died, serial number 2, my lord. Serial number 2.
All right,
He is supposed to have died in 69.
all right.
That is taken to the next.
So this is a disputed question of fact.
Even the Sarpanch is not competent.
Yes.
That's submission, my lord. Second submission is, my lord, just now your lordship previous case was, my lord, it's the revenue entrance. It's the revenue entrance. Revenue entrance, well, their name has been deleted. My vendor's name have been incorporated. I am in position from the date of purchase also. Well, revenue records will not convert, like your lordship just now said, my lord. But ultimately, my lord, this will create, after 48 years, their names are being changed. After 20 years, their names are changed from 2003 or 2004, my lord. This will create a nuisance for the plot owners because, my lord, I will repair the loss, my lord, because they can't get permission to construct their houses. Already they are in position, they have constructed compound walls. So that is the second area, my lord. Third is, my lord, entertaining a section 9 revision after a gap of 20 years or 48 is what the case, my lord. Even your lordship have been holding consistently that revisional powers cannot be exercised, my lord, after inordinate delay. This is the third point. Fourth aspect has been, my lord, these plot owners are bona fide purchasers. Their layout was not declared. They went to they got some LRS and also they went to consumer forum and got it. Now, my lord, by virtue of this order, my lord, their rights are disturbed, my lord. These are the four aspects on which I make my submission, sir. Now, as I was saying, my lord.
All right, so enough for what interim order you are taking.
I am seeking suspension of this order.
Why? What does it do?
My vendor's names are there in the revenue records. By virtue of this order, the names of 1970 person and the dealers will be restored back.
All
But in all what Pahal is, it's shown as house sites. So before my friend begins, once the nature of the land has been converted to house plots, my lord, the revenue authorities do not have a jurisdiction to even entertain this. That's my fifth point.
So according to it has been converted from agriculture to non-agriculture.
Now, what do you say? Except notice. Except notice.
Yes, and the response 5 to 12 I have expected.
5. Why are the contesting response?
Yes, contesting response.
Yes. 5 to 12.
Yes.
All right. Yes. Yes, please. So, inordinate delay of how many 48 years in approaching the revisional authority?
Not necessary. I'll just point out, in 1 minute, let's the revision which we prefer before the joint collector response number 2 is with respect to survey number 108 at measuring 3 acres 28 guntas.
Survey number
108, 3 acres 28 guntas of Narsingi village.
This is not in dispute. It doesn't belong to them.
Absolutely. That's the
Some of the plot permits spread over various survey numbers. Some of the plots 108 also included the layout.
Oh, 13 acres.
3 acres 28 guntas of Narsingi village, survey number 108.
That is not in dispute.
That is not in dispute. But what is disputed is, now.
No, we are asking. You have heard learned senior counsel.
I'll just 48 sentence that would do. Now, the appellants before lordships were the writ petitioners. They are third parties. They are claiming rights over survey number 106, not 108. All their sale leads produced
survey number
106 of the same village. And they have nothing to do with the survey number 108. All the sale leads, I will point out in the document itself. All the documents they have produced stating to be their purchases from their vendors who are the developer.
So, 1 second. Now, shall we clarify? In case it is so that are you interested in land bearing survey 106?
Survey 106, 108, 115, there are about 20 survey numbers.
All right.
Only sample cited, but I did not all the sample cited.
No, in that case, we could have said that the order does not apply to the land held by you. Right? We could have clarified.
Not it is also there.
Well, let's kindly go to page number 209 for a moment. 209. It is the sale deed not pertaining to the first appellant. Milord, this
No,
is-
so why you are not answering that 48 years after this thing invoking revisional power and land converted into non-residential purposes, how revenue authorities will have jurisdiction to deal with this thing prayer for mutation of names?
I'll clarify that.
Tell us, we will go into, they are saying they are interested in all the lands, 106, 118, 115, 108, 106, everything.
Produce any such layout, which the wherein showing that surrender to 108 also included in the sale deeds covered by the updates. Well, that's the reason why I wanted to point out.
All right, we are entertaining the appeal and we are.
That's one submission. My responsible submission is, well, the appeals before lordships have neither locus nor aggrieved party for the reason that Milord, this survey number 108 is not forming part of the sale deeds executed in their favor. Page number 214 lordship at LEC for a moment.
All right, got it.
14. Then lordship at LEC, all the hearing number so and so is forming part of 106.
You heard senior counsel saying that we have not annexed all the sale deeds. In case you are serious about it, we will record your submission and then we will ask them to file all sale deeds. And if your statement is found to be false, consequences will ensue.
In fact, they have already filed and pointing out from their own legal papers.
He has not filed, he said so.
Sample sale deeds are.
Sample sale deed he has filed, all sale deeds he has not filed.
I would believe lordships have only 4 in number. I am only confining to the appellates before lordships.
The layout is specified now. How many survey numbers, my lord? I find sample sale deeds of.
No. So see, Mr. We can very well, he agrees to this. We can very well dispose of this appeal by saying that the directions contained in the order passed by the learned single judge will not apply to these 4 appellants.
4 appellants, my lord?
Yes, that's the scope of the appeal. Correct? You agree?
Well, it's
Mr. If you are saying not agreed, you should agree for this. We are saying that we will just now dispose of the appeal, saying that the directions contained issued by learned single judge will not apply to these 4 appellants because they, according to you, they don't own the land. We will not apply. If you agree, if you are sure about it, just now we dispose of this appeal.
Well, the entire proceedings carried before this honorable court,
Then
pertaining to survey number 108 millets. Now, let them establish how they are concerned with survey number 108.
Then
Unless they produce any record.
Then it requires admission and stay. Just now you are trying to make it so simpler. So we have tested. So see, cat is out of the bag. You are not agreeing. Supposing if they were totally unknown to the land, you should have said yes.
The level single judge shows pleased to dismiss their petition only on the ground that they are no locus because they are not agreed parties because they have
No, we have understood. This will be required to be adjudicated. Yes, otherwise we would have disposed of by saying that this directions contained in the order will not apply to the appellants. If you agree, say so. Otherwise, we will admit and grant interim order.
Well, that would be virtually amounting to allowing the writ appeal. No, my contention is that Miller, who may consider
No.
unless they
Just
say,
a minute. Have you filed a caveat? Caveat you have filed?
let's say it's a,
No. We are asking then. You just now said anything. Admission of an appeal amounts to allowing the appeal.
no.
Supposing just a minute. If you would have been an appellant,
Just a minute, sorry, Miller.
listen. If you would have been an appellant, your appeal is admitted. Does this mean that Mr. Praveen Kumar will think it has been allowed? This is admission means. Admission means it requires consideration.
The points are raised. That was not my intention. I only pointed to if that is
You are not on caveat. This is a courtesy being extended to you. You have no right to be heard at this stage.
let's say appeals whenever LP is filed, we are not filing any caveats, Miller.
That is not a caveat. That's it. You are not.
Because it's accepted.
Advance notice. No objection. Yes, heard on the question of admission. In this intra-court appeal. Mr.
Yes,
You can file, you accept notice on 5 to
yes, same.
5 to 2. Same order.
So say GP for revenue.
GP
GP for revenue accepts for 1 to 4.
You are not standing up what to do.
Perform. As a statutory authority, my lord, you're not supposed to take
So
counters.
the GP for revenue accept notice. Or list, I think is gone there. GP for revenue accepts notice one in both the cases, 1 to 4. Yes.
Obliged.
And that, this thing just now he has given a synopsis, you keep it in the file, staple. Just now he has given, no, staple that. Otherwise it will be, this is 4, no? So this was item 4, madam.
4 and 23.
You have got that, this thing, synopsis.
That synopsis.
Keep it properly. Yes. Yes.
Item 5, merit list box. But there are 4 miscellaneous applications. But if I go to the main case,
We are issuing notice on this. Mark the presence learned senior counsel heard on IA 1 of 23, 2 of 23. And personal service, whatever.
this what have early, so that
You serve it as soon as possible. Make
other
a,
side is here. Because our practice in legislated appeal.
nobody is there.
My lord, I am appealing for the respondent.
Oh,
Yes.
acha.
Lord,
So you will, the,
As far as they dispense with application and also delay condemnation, my lord, because the appellant before lordship was not a party to the petition,
that's why.
I cannot have any objection.
Yes.
But dispense with and the condemnation,
And,
I have no
all
objection.
right, that's why.
So
We
this,
can have it someday.
these 3 applications.
All right, allowed. So heard on Mark, everybody's presence, heard on IA 1 of 2023. For the reasons assigned in the application duly supported by an affidavit. We take it that you have said that you will not register.
There is the injunction. There is the
And
injunction.
please, like a previous case, if you give 28. Any person aggrieved by
28.
30. This thing, correct? That's it. Mark the presence. Anything else you want to say?
My submission is my right.
Appeal lies under section 28. You are wrong in saying so that no appeal lies. And any person aggrieved, not party, any person aggrieved. If you are not a person aggrieved, you cannot maintain the writ petition. If you are a person aggrieved, file an appeal under section 28. We can't examine everything in writ jurisdiction. Under article, it is extraordinary discretionary jurisdiction. Merely because you are a farmer and a villager, that doesn't mean that you are not bound by law enacted by parliament.
That's not happening. That's not my,
It's not that you don't have a forum.
my only submission before your lordship is, without even any permission from the competent authority, the ninth respondent is proceeding with the construction. That's my main.
That is this case. That can also be taken up.
It can be taken up before the appellate authority. We will say
There is an appellate forum at Langdikapur. It is only between High Court to Langdikapur. That is the only distance. You are
Yes.
right, file as say there that he is not doing so and all this. 226 is not meant, right, for this, correct? This is a forum created by law. Yes. So will you file
Yes,
an appeal? How much time? We will then direct the appellate authority to decide it in a time bound manner. If you file, how much time will you file?
I'll file within 2 weeks, man.
Correct. That's correct. In this petition, mark the presence in this petition, comma, the petitioner yes. Who appears? Nobody. Ask him. Ask.
Mr. Prabhakar, this is a notice. You can file objections. You are not audible. What happened? It's not audible.
What happened?
Great respect to the Honorable Court, I have already filed objections, my lord, at page 97, my lord.
No, we can do it from there.
No, like this.
Not audible. Why?
Lordship,
Pass it over and ask.
Lordship, audible, Lordship.
Mr. Prabhakar, we'll pass it over. We are unable to hear you. We'll pass it over and you come back at 2:30. We'll hear.
Lordship, with great respect to the Honorable Court, my lord, I have a personal inconvenience. I have it tomorrow, my lord.
Superannuation benefits have been withheld. This
Sure.
matter may have to come before the single bench, my lord.
Acha, okay. So how it has been listed? Let the writ petition be listed before appropriate bench as per rules. Yes, as per rules. Yes, next.
Lord, this is a matter wherein, my lord, agreed by inaction of respondents, my lord, the Pollution Control Board, in taking preventive and criminal action against the pharmaceutical industries, my lord, which are.
Appears for pollution control. You don't take action and people rush to this court, right?
So I'll get instructions in this matter, I'll report.
My lord,
Find out what have you
Yes,
done.
environmental compensation of, my lord, 18 lakhs is already levied, my lord.
One second.
First responders, not one first.
For the time in 7 to 15. There is the matter will be entitled for inaction of the state. Heard on the question of admission, learned counsel for the petitioner submits that the petitioners are owners of land in question and their lands are situated adjacent to special economic zone wherein the industries of respondents number factories of respondents number 7 to 15 have been set up. It is further submitted that what they are doing, they are causing pollution.
They are releasing the effluent, the harmful waters into the streams and the lands of the petitioners, my lord.
It is the grievance of the petitioners that respondents 7 to 15 are releasing the effluents and
harmful substances
to the water bodies of the petitioners. It is also pointed out that several complaints in this regard has been made to the Pollution Control Board. However, the representations submitted by the appellants have failed to evoke any response from the Pollution Control Board. Paragraph, Mr. Praveen Kumar, R1, and then
For 2 and
you
6.
appear for
I'm appearing with the respondent number 4 with the pollution control.
4 and Madam
For respondent number 2, additional educate general officer.
2 for additional and 4 learned counsel for at the for the time being full stop the or delete the respondent counsel for respondent number 4 shall seek instructions and shall submit a status report.
Yes.
Status report with regard to the action taken in response in pursuance of the complaints made by the petitioners. In case the grievance of the petitioners is found to be justified, appropriate orders on the next date for service of notice on respondent 7 to 15 shall be passed.
Personal notice.
Personal notice.
Yes, I will. List after 2 weeks.
I may be permitted to take personal notice.
No, we have issued notice only to official respondent for the time being.
Obliged.
Then we'll, depending upon their status report, we'll see what happens. You tell us. Then we will issue notice.
Obliged.
7 to 15. That's what we have said in the order.
Obliged. Higher.
Yes. So appeal.
May I please your lordship, sir? I beg to present on behalf of Nageshwara regarding sir.
That's correct. What happens to an appeal?
It's the appeal provision, my lords. Here is a vacation notice that being challenged before your lordships, my lords.
It's a measure taken under 13(4), right?
My lords,
You are a person aggrieved.
my lords, I'm a person agreed, my lords, but your lordships would see, my lords, under section.
Madam, where is that SURFACE Act, the order that, no, order we have passed, I told you can give that SURFACE Act.
Section 17.
That case law, the Satyavati Tandon and those people go out and not. It's all like in a folder, you keep it here, madam. Where it's here?
Yes.
Sorry. What you say? Yes. This way. Yes.
May I, one.
Is there an interim order?
I have not filed a section 17 petition, Malats.
You file.
I am a lessee to the secured asset, Malats.
Any person, section 17, any person aggrieved. Not party, it's not party to loan transaction.
Any person, any order.
Aggrieved.
Both are there.
Any person aggrieved. So you are a lessee aggrieved by transaction taken between your owner and bank.
1.1.
So it's very good, right? We take loan and set up somebody, then lease out the property and lease out the property, take loan and our tenant fights the legal battles on behalf, like filing a writ petition under Article 220. Parliament has taken note of such a contingency in this petition.
One small topic, Malats, and I rest my case, Malats.
This is an order under section 17 of 13 of SARFAESI Act.
Section 14, Malats, section 14.
14 is also applicable.
Subclause 3 says, Malats, the order of.
Section 14 order is also applicable under section 17.
If I may.
All right. This is an order under section 14, right?
Your Lordship, I may read one point, Malats.
There is a case law. Rahul, law clerk, Rahul. It's an order under section 14.
Malats, I am supported by the judgment of the Honorable Supreme Court, Malats, when a section 14 application is there, Malats, no remedy lies in the section 17. Malats. By virtue of
That's
section
what we
14,
wanted to show. Show. According to us, Supreme Court has said that even an order passed under section 14 is applicable. You are sure about it?
Yes,
With
I
what
am
the-
supported by your Lordship, judgment of the Honorable.
We are also saying Supreme Court.
Malats,
This was. Yes, any counsel who is there appearing for banks, we don't think this is the correct law. Subsequently, Mr. 6 and 9 years have passed. We are in 23. This is 2014 judgment. It lies. Appeal lies.
Malats, your Lordship, for one moment, see paragraph 29, Malats. Paragraph 29 at the part.
Ask him. Mr. Jadhav.
Mr. Jadhav, this the judgment of the Honorable Supreme Court in Harshad Govardhan Saundagar.
Yes, my lords.
Saying that section 17 is not applicable for orders under 14. This
That has been diluted. It says appeal lies.
Appeal lies.
He is not aware.
My lords, earlier it was that model because the tenants, because aggrieved person, the redelivery of the possession was only for the borrower. So subsequently, Harshad Govardhan, whatever, my lordship, they changed it.
No, but after Harshad, it is said even an order under,
Yes, my lords.
2014 volume 6 SCC page 1 is Harshad.
Yes, my lords.
This has been diluted subsequently and Supreme Court has said that appeal lies.
Bajrang Shamraj.
What is the citation?
Citation 5 minutes, my lords. Short.
Which year? Name of the party?
Bajrang Lal Sham Sundar. I'll give the short citation, my lords.
What is the citation?
Justice
Which year, Mr. Just
2022, I think. NV Ramna, Justice NV Ramna's bench, my lords. 3 judges. I'll give the citation. In short.
Appeal against an order passed under section 14 of the SARFAESI Act lies under section 17. Got it? Under section 14, not the usual one, right? We have this order. Appeal against an order passed under section 14, not 13. 14 lies. Bajrang Sham Sundar. See here only. You will get it.
This 2014-6
Has been
one would have been
distinguished and overruled or whatever.
This is the judgment dated 11th September 2019, my lords.
11th
September 2019, my lords.
See, Mr. Citing an overruled judgment before the court is a misconduct.
I think to apologize for the.
And then don't apologize. Be more cautious. We can issue your notice for professional misconduct. Citing an overruled judgment, ask everyone here, your seniors, it's a professional misconduct. What you should say, this according to me, we told you because we have dealt with it. Order under section 14 is an order applicable under section 17 of SARFAESI Act. What, Mr.? Be more cautious. It can be a bona fide error also, we are giving you the benefit of doubt. But you are a young man, be more cautious, right? Be more cautious.
I deeply apologize.
No. There's no question that's fine, but be more cautious in future. That's the word of caution to you. Always check up. You can find out instantaneously, right? Whether it has been overruled, distinguished, whatever. Don't do like this. Because we knew it, right? We knew it. What do you think? Supposing if we have issued notice, the counsel for bank would not have told us that, sir, this is an appealable order. Don't engage in short-term practices which lead to short-term gain. You will lose once you lose a face before the court, nothing survives. Correct? We will always remember now when you appear, oh, he's citing some judgment, he may be citing overruled judgment. That's the impression. In this writ petition, the petitioner has
liberty to approach
that liberty we are bound to grant.
Amendment 2018, the borrower was loan entitled for redelivery of possession. So section 17 was entitled. So tenants were not entitled for redelivery of. Subsequently, what happened? Amendment was carried out, my lords, in 2018. Thereafter, even tenants can approach under section 17, my lords.
Right of appeal is provided by way of an amendment in the year 2016.
That is how. I limited endeavor, that
No endeavor. Limited endeavor is not to cite overruled judgment. Correct? Henceforth. That person is not impleaded who, according to you, is heading forensic scientist lab.
My lordship.
He has to be impleaded, right? The result of the petition would be that he would be removed.
My lordship.
You, according to you,
yes.
Telangana State Forensic Science Lab is not being headed by forensic scientist as per government order. Then, and it is currently headed by IPS officer.
Yes,
that IPS officer has to be implemented. Proper party.
We have put Telangana State respondent number 3 is mentioned, my lordship. Respondent 3 is the director, Telangana.
No, this is director separately, Mr. No. But some person by XYZ
exactly heading, he has to be implemented, no?
It is continuously being headed by police department only, my lordship.
Whosoever is heading, you file. Otherwise, we will have to say that proper party to the list has not been impleted, therefore we can't entertain this. It's a public interest litigation
Yes,
in any
madam.
case. Nothing to lose. You are not going to be appointed as head.
My lord.
Right. Complete.
My lord.
You have to, you are an officer of the court, right? In public interest litigation, carry out. We are asking you to. Don't resist like a private interest litigation. No, no, it's my petition. I will not do it. Your locus is gone now. It has, we have read the petition. You are out of the petition now, right? Appear only as a officer of the court. Learned counsel for the petitioner undertakes
Actually, your lordship.
Yes.
It is with regard to the suicides committed by
What
students
should
and
we
inter-
do?
My lord, every year
No,
since
see,
20
we are-
years.
Giving a lecture is fine. Every year, so many we know that it's a menace.
Yes.
You please give us suggestions what the government should do. You have not done anything.
Yes.
Which guideline they are required to follow, what precautionary steps they are required to follow. What, I mean, the petitions are absolute, the averments are absolutely vague, though your intention is good. We want to do it, but you give us some material. What is the data? What are the, find out what are the guidelines, if any, across the world. This is a world of internet, right?
Yes.
You have to assist, do it. What is the data about suicides? What precautionary steps, in your opinion, they can take? They will be more than willing.
Yes.
Not like this.
Yes.
Do it. Make a research. It has to be properly researched with petition, right? Not like casually feeling that you just like morning thought and gave dictation.
I have not mentioned, my lord.
Nothing
I have
mentioned.
not mentioned, my lord.
Nothing is mentioned. In this petition which has been filed as a public interest. Everybody wants, but what should be done? You find out.
My lords, learned additional petitioner takes notice for the response, my lord.
No notice. First he will tell us.
Yes.
You also find out what can be done.
Yes.
Except, besides accepting notice, you find out what can be done.
My lords, certainly, my lords.
Yes. This needs.
Silent to appear for the respondent writ petitioners, my lord.
So this requires a hearing and Mr. Advocate General, list of dates first. It has a checkered history, first rounds up to Supreme Court, then second round. Please give a list of dates so that we cut on time. Otherwise, this very case will go on till 4:30.
Yes, my lords, I will certainly assist your lordship.
Please just give.
My lords, the earlier
Chronological list of events, please give.
the cause of action which went up to Supreme Court, my lords, on two aspects.
This all dates have to be mentioned, otherwise we will be busy writing what happened when
My lords,
they were granted.
The dates and events and also a small synopsis.
Give us
how the learned single judge expanded the scope.
So what date? You also feel free to give us.
I'll prepare
Learned
2
counsel
pages.
for, yes.
Yes.
Learned counsel for the parties undertake to prepare a synopsis and produce the same. But we will have to state so many facts, right? You'll have to please assist us if you want the case to be heard in motion hearing finally. So please,
It is actually, my lord, it is coming up for admission. But it is shown in the cause list as per orders.
all right, if you don't want to, then we will adjourn it.
No.
We will ask our law clerks to prepare a list of dates if you don't want to.
I'll prepare.
But we
list
will
of
only
dates.
hear you then on submissions only, and you will have to conclude in 10 minutes. Right? That, on that ground, then we will hear. See, Mr. These are all matters of 23. You cannot be heard of this thing out of turn and 2005 person be kept waiting. You have been appearing in such old matters. That is what. So if you want us, we understand the importance involved in the this thing. So, but help us in some way so that we can decide it within, you can conclude within 15 minutes.
Yes.
We can't like hear this case from 4:30 and everybody is kept waiting. It can't be like.
Yes.
This is 23 matter.
Yes.
Please give.
Yes,
Mr. Advocate General.
Will serve in advance.
And,
my friend
yes,
also.
and
Yes.
make submissions and case law.
We'll
also.
confine to the
You write-
material question.
So
Yes.
everything.
Yes.
So you can proceed faster. It's
yes,
a short issue involved.
Yes, I'm deeply obliged.
Yes.
May it please your lordship.
Yes.
For the applicants, my lord.
Record,
Yes, my lord.
land acquisition records.
Yes, I have.
You have?
Yes.
Yes.
On the previous occasion, your lordship also directed me to prepare the chronology of dates so as to.
You are respondent, we believe.
Good. But to assist the court.
Yes, sir. No, we appreciate this. That's what in the previous case we told that. In case you want us to, then it should be.
And your lordships are right, my lordship, that devil lies in the detail. Your lordship last time pointed out, while I go to bring through the devil lies in the detail. Your lordships are correct. That I found out while preparing this, that
You hardly have any option but to agree with us.
Of course, yes, sir.
Yeah. Lighter vein.
It's reaffirmed.
Lighter.
Yes, it's reaffirmed.
Issuance of 4-1. Let's see how it makes things simple. This was under 1894 Act. Mr.
Yes, your lordship.
So you should have written that 1894 Act.
Yes.
416. So dispute is that their case is that they have not touched your land in any way and they never entered.
Not emphatically, they are not.
That's what they say. And you are saying that you are entitled to, we remember, use of this thing for under section 35 because they have caused damage by digging 4 borewells.
4 borewells and placing the generator, and 4 years I was not able to cultivate because there are ingression and aggression, and electrical lines also passed through my land to the tunnel.
So Mr. The question whether any damage is caused to your land.
Yes.
Has to be first established, correct?
I filed photographs and
no.
Yes.
That has to establish.
The next step has to be taken.
And please understand the query.
Yes.
It can't be in a summary proceeding under Article 226, right? So if there is this fact is adjudicated that they have caused damage to your property, then you are entitled to compensation. So whether the forum prescribed under section 35 provides that of adjudication that you have to prove that damage was caused. What does it say? Section 35 Land Acquisition Act.
That's in that 7. Yes.
So then you have to prove that fact, no?
Yes.
Before you have to prove that fact or not?
Yes, sir. The fact.
This question, whether or not they have caused damage, can be gone into in a proceeding under section 35.
See, the reason that irrigation departments made a party to submit exactly their government, that was not done so.
What is the answer? What do you say on this? 35?
Yes, Your Lordship.
Whether this question can be gone into?
35, that's not, Your Lordship, the collector. If Your Lordship may permit me one submission, if I can make, Your Lordship. 35, 36, that's all. This chapter, part 6 will be applied to me.
No, 35 may not apply.
36, my lordship.
35 may not apply because this procedure under 35 has not been followed.
Yes.
They have forcibly taken position, right? 36.
They take full position. My ground is they have taken position for 4 years.
When? How?
I did send the details all I given, my lordship, with the page numbers, appropriate governments and.
26 deals with regarding executing an agreement. So this also does not apply. Starting line of the section deals with that.
May make one submission if you lordship.
What is the forum, Mr. We are trying to assert, Madam, please assist.
Section.
No. The controversy is narrowed down only to the extent you are saying we have not touched your land, we don't want your land, right? He claims that you have taken possession of his land for 4 years and you have utilized his land. Therefore, he is entitled to claim compensation. So we are very clear on this, that this disputed question of fact needs adjudication before you are made to pay compensation. And then secondly, quantum of compensation is assessed. We are only trying to ascertain what is that forum. Please tell under which these two questions can be gone.
Section 5 of
1894 Act.
But before even that, we are objecting that denying the contention that we have entered into the land and damaged property. But submit my contention.
No. That's your case where you have not entered. And perhaps in a proceeding under Article 226, it can't be done.
Yes.
We are.
Yes, it's the district collector who has to assess the damage under Section 5 of the 1894 Act.
Correct. Section 5.
Your lordship may kindly permit one submission.
1 minute.
One submission, lordship.
Hey, we will hear you.
I agree.
So what the learned single judge has done, madam? What has learned single judge done?
To acquire the land.
It's mainly based on the ground that have entered the surface, disturbed their position and taken and not paid compensation.
Alright, so but
Initiate proceedings and pay compensation.
so when possession was given to you, Mr. of your land?
2019, my lordship.
When?
I specifically mentioned, my lordship. 2019 September, from Rabi, October, I managed to cultivate Rabi cultivation.
And so from July 2014, according to you?
Yes, your lordship.
September. All right, madam.
From July to 20.
So correct, we will modify, madam, listen, we will modify the order last by learned single judge, set aside the direction to acquire the land because he is already in possession, right?
Yes.
Now the question is only for a period from July 2014 to September 2019, whether or not you have utilized his land and caused damages. You say you have not touched, you never entered. He says it has been done. This disputed the question of fact cannot be adjudicated in a writ petition. The forum you have told us, we will ask him to lodge a claim under Section 5. The competent authority under Section 5 will conduct an inquiry. If he is found entitled to this thing, damages, the quantum of damages will be assessed. That's it.
Yes. But that.
So simple, right, madam?
Yes.
Yes.
I agree. One submission I put in.
For you, when we tell her, we have to tell you separately, you didn't hear. Because we explained to her because it's her appeal.
Yes.
And we expect that you are listening to us with all.
I listened to your lordship. I only want to bring a small issue to your lordship's notice and leave it.
No issue. What issue?
All this complexity happened because 2014 they were still in occupation. I filed the case.
We don't know. We don't know. Listen to the order which is
because of the lapse of the time, the nature of prayer has changed. That's the only submission I made. I leave it to you, Lord.
No, nothing. Don't leave it to us. We will leave it to law. We will leave it to us. Mark the presence. This intra-court appeal is filed.
not passed by the time after initiating.
Ah,
It continues under the till the award. But section
however, this thing lapsed in the years also, huh? We need not advert to delete thereafter sentence. We need not advert to the question whether the proceeding under 1894 Act applies, applies, applies as the possession of the land in question was not taken under the old Act. We need not deal with the impact of effect of section 24 of 2013 Act in the facts of the case, as the possession of the land in question was not taken till
Never taken.
till commencement of 2013 Act. That is, what is the date of new Act? First, 1/1/2014. 1/1/2014. Full stop. The full stop. The jurisdiction of this court under Article 226 of the Constitution of India is summary in nature, and in exercise of the said jurisdiction, disputed questions of fact cannot be adverted to. Full stop. Paragraph. Therefore, in our considered full stop. Admittedly, the petitioner has been placed. Admittedly, the landowner. Paragraph. No. Admittedly, the landowner has been placed in possession of the land in the month of September 2019. Therefore, the question of acquisition of his possession of the land in question in September 2019, and he is cultivating his land. Therefore, at this point of time, direction to issue therefore, at this point of time, question of issuing directions to the appellants to acquire his land does not arise. Full stop. However, the fact whether or not the appellant, whether or not the respondent, the appellants had taken possession of the scheduled land from the landowner in July 2014 and placed in possession and were in possession till September 2019 cannot be gone into in this proceeding. Full stop. Paragraph. Section 5 of the Act deals with payment of damages, which reads as under Code Section 5. Right? Full stop. Paragraph. There in the facts of paragraph, in the facts of the case, the parties are required to be relegated to the forum provided under Section 5 of the Act, so that this disputed question of fact, whether or not the landowner was dispossessed in July 2014 and July 2014 till September 2019, and whether he is entitled to claim damages, if yes, to what an extent, has to be decided by the forum prescribed under section, has to be decided by the collector under Section 5 of the Act. Needless to state that the parties shall be entitled to adduce evidence in support of their claims. The collector shall conduct an inquiry, and after adverting to the material adduced by the parties, shall decide the question whether or not the appellants were in possession from July 2014 till September 2019, and if it is found that the appellants was, if it is found that the landowner was kept out of possession by the appellants from July 2014 till September 2019, the collector shall also decide the quantum of compensation to which landowner shall be entitled. Paragraph. To the aforesaid extent, order passed by the learned single judge is modified. In the result, appeal is disposed of.
Damage of well is also apart from position.
Whatever. Damages, whatever.
Well, damage, open is damage. That's only.
Right. Open to, it will be open for the parties, Mr. to adduce evidence with regard to their claims.
Damage of position.
Everything. Including damages means that only, whatever. We are not saying only well and just thing. Yes.
Lordship, time period, Your Lordship, may kindly please.
Within a period of 4 months, madam. Needless, the collector shall conclude the aforesaid exercise within a period of 4 months from the appearance of the parties.
Much obliged.
It's not corrected, it's not Anandagiri reservoir, it's Annapurna reservoir.
Annapurna Reservoir. In the opening paragraph, you have written Annapurna Reservoir. Yes. Next. Yes.
Relation between on the lecture paper, the other goes after
Demolition.
Mr. Sridhar, the demolition has already taken place. Yes. Nothing, the demolition part, only during for some period it was stayed.
No, my grievance is, my lord, even the demolition which has taken place, it was in violation of principles of natural justice.
What we are asking is, the demolition they have already undertaken.
Yes.
Correct?
Now you will be entitled to damages.
Compensation.
Compensation.
But that the learned single judge directed us to approach the civil court. My contention is that
See, we can,
even before
in
the
this proceeding, we understand that it's your right under Article 300A has been violated. Therefore, you are entitled to compensation. But at the same time, we will tell you that we can only grant a token sort of compensation. We cannot go on actuals like and quantify. You may have suffered a loss of 1 crore. We may not grant it because we can't ask you to adduce evidence and then decide this thing. If it is held that this has been done, then you will be entitled to a like token sort of compensation, whatever we decide. Correct? It will not be actuals. That position clear to you, right? That violation of a constitutional right, the court can fundamental right. In fact, we are extending it further that even let us assume that it goes to constitutional right also. Then also you will appreciate that quantum may not be possible for us.
My only request is, my lord, let there be a finding with regard to that. That's
Fine.
Well, at that.
So what?
See, why we are saying this is, there is a finding that there has been encroachment onto the frontage.
They should
And your vendors from whom you have purchased the property and carrying on the business of running shops and other things needed to be proved. So that is why the learned single judge said, go before the civil court.
That is precisely my argument.
So
carrying any inquiry, my lord, they give notice on 22/7. I give reply.
What about this thing? No, the learned single just said that res judicata also. What do you say with regard to res judicata?
That, my lord, I have specifically stated in my affidavit that
Earlier you filed a writ petition, correct?
after the disposal of the said writ petition, my lord, again they have marked by premises.
No, what was the previous writ petition?
Previous writ petition.
You have annexed a copy.
After demolition.
Annexed a copy of the petition.
That is not filed.
That is
Please file, so that learned, how much time?
Day after tomorrow.
Learned counsel for the petitioner undertakes to place on record copy of writ petition filed by the petitioner's name, previous writ petition filed by the petitioners claim for compensation in a proceeding, give us a case law. Fundamental right compensation can be granted even for constitutional right and the disputed questions of title, whether you are an encroacher, owner, it can, we all can decide. Please
Exactly.
see.
That is the judgment of the other Supreme Court.
Yes, next.
Yes.
20, this was 19. At-
Both
This
18
was-
and 19 go to.
Go to, yes, okay. Yes.
May I prepare, Your Lordship?
Yes, please.
Where this bill filed by me, Your Lordships, the unofficial respondents make the malpractice, Your Lordship.
Only one college in the whole state.
Likewise, I stated likewise.
Where is?
We have
Other colleges.
have made likewise in my prayer, Your
No,
Lordship.
no, there is no like pre-regulatory committee in the state of Telangana.
The official respondents to take, Your
No,
Lordship.
no. There is no fee. I am asking, I am this thing. I knew in Karnataka there is a fee regulatory
Here
committee
also.
everywhere.
Here
So
also.
there must be a fee regulatory committee here.
Yes.
Have you gone there saying that this R11 is charging more amount than?
Yes, Your Lordship. What happening, Your Lordships? They are opening offline, online.
No, did you approach with regard to grievance?
I have approached
that from these students? This was the the due fee, and this is what has been recovered. Saying like that they are not following law is very easy.
No. We have traced, Your Lordship, their malpractice. Then only I have filed earlier also I have filed writ petition. I got one seat also. Earlier affidavit also I have filed, Your Lordship.
But this is public interest. You can't claim any relief. That's the objection.
Yes.
That the cat came out of the bag that I got one seat. So this is one seat meant for you in this PIL.
I am not seeking for one seat, Your Lordship. Page number 29.
You said earlier
To take
petition.
action.
Approach fee regulatory committee. When did you submit? Tell us where is the representation, where is the receipt of this thing? Fee regulatory committee.
For fee regulation, it is not the fault of fee regulation committee. Your Lordship. It is fixed. It is there. But we
No,
are following the individual petitioners.
There has to be a mechanism for every grievance.
Yes.
Fee regulatory committee is constituted, to my knowledge, in where the High Court where I worked under an act. That fee regulatory committee's functions are enumerated and in that provision that includes collection of excess fee. Everything cannot be decided under Article 226. Please appreciate.
Your Lordships, in earlier
Anybody is polluting the agricultural land, then also 226. Collecting fee from students, then also 226. There is a fee regulatory committee, and we are sure, please show under which enactment fee regulatory committee has been constituted. What are its functions?
Your Lordship. Fee regulation committee is fixed the rates, Your Lordship. I am not disputing rate. Where?
Mister, we understand not disputing. Your grievance is in excess of the rates fixed by it is being charged.
They are not even allowing the individual students, Your Lordship. Only they are access to their agencies, Your Lordship. When we are going to through the agencies, they are allowing me by getting 50.
To which authority have you made a representation before coming here? Tell us what date you have filed.
I have made your page number 14, 82, Your Lordship. Page number 82.
When this petition was filed?
This is the 223, Your Lordship. 22. Kindly see.
Where have you filed it? 21st July 23, right? This petition was filed on 21st July. When did you make a representation? Where is it? To whom?
Page number 82, Your Lordship.
82. 82.
This July I have made in.
So you made some time in the last year. Srinidhi Engineering College.
23 I did not make, Your Lordship. 22, Your Lordship. I have filed.
This year you have not. This is separate.
Every year they are doing the same malpractice. Your crores of rupees is changing.
Who has taken where? I mean, crores from whom? Well, saying this crores of rupees is very easy, right?
This is the open secret, Your Lordship. All the parents well known in that state, Your Lordship.
This is engineering course, right?
Engineering.
Nobody gives fee in crores for an engineering course. That is our experience of life. If you would have said MD dermatology, we would have MD radiology, we would have understood that it's 1.5 CR officially management quota. But
10
who
to 15 lakhs per each
engineering
student.
people,
Thousands of students. that
Mr.
is my case.
Engineering people don't get admission, the seats are unfit.
10 lakhs per each student, so 10 to 15 lakhs you will actually. Not I'm saying for single crore for single person.
This year you have not made any grievance. How have you approached? Tell us, Mr. And saying this, 10 crore each student, where is the material?
No.
Who is
10 lakhs, 10 lakhs per each student.
So the student who pays 10 lakhs can come to this court.
10 to 15
Tell
lakhs.
us for this year, where have you approached the authority before filing the PIL? This is this thing. You just now admitted last year. Please approach and then file. If it is not
Actually,
addressed.
If to approach also there is no tenure, only 3 days tenure. 3 days also, 2 days is declared holiday by this state government because of the rain, floods. Even though they are giving publication as per the fourth respondent, but they are not always.
For which academic session they are doing fraudulent tax according to
Every year they are doing 22, 23, they are did they have publication made, your lordships?
No. This petition is filed on 21st July 23.
Yes, this was filed
21st
July.
So please tell us.
So kindly see your lordships, page number 60. Page number 60.
When did you approach any of the authorities before filing, or straightway without you tell us that straightway PIL can be filed without approaching anyone?
Earlier I have approached. I am seeking
This
direction on my complaint. Earlier complaint.
This is, read your complaint, page 82. What have you said? You read.
Parents of the engineering BTech aspirants who went to the address given by the paper notification in the Andhra Prabha district pages. Hence, we have seen both Bangla and one is then, translated page number 84. I am reading.
So one is them to receive application. We have seen
both paper notification in Andhra Prabha.
What do you say, booth bungalow? We have seen booth bungalow.
Yes, your lordship, they are making wrong address also, your lordship, earlier happened.
See, read, what can we make out, mister? I mean, explaining it is different. I mean, it should be discernible. Don't take, read further, what is it?
We have gone through the website.
We as a parent of engineering aspirants.
May I read your lordship? Paper notification in the Andhra Prabha pages, there we have seen both Bangla. No one is there to receive applications.
Read from the beginning. We as
a parents of engineering B category aspirants.
So if you are a parent and you made a last year this thing complaint that this can't be public interest because you are vitally interested in result of the litigation. Do you understand? This complaint was made by a parent of person. We as parents, complaint made by parents.
This year, actually, admittedly, I did not.
And see, the student's name is given all 1, 2, 3, 4, 5, 6. The parents of these 6 students have made a complaint.
These are the parents.
Parents' name has also been given. So this can't be public interest, mister.
Earlier, they are the petitioners, your lordship.
No, do you want us to
How
say?
is it public interest litigation when they are they have an interest in the entire litigation?
They are seeking.
Now,
if your bill is based on this complaint, they are the interested party. They can't maintain a bill.
Simple.
Now
thing.
with the petition,
you can file a writ petition, not a public interest litigation. Understand?
Understood, your lordship.
Then
this complaint made by the parents, now bill filed by the students, your lordship.
No.
University scholars.
No.
The bill now presently filed by the
You have said that university scholars, they are students.
But who is the PhD students, your lordship? They are PhD students. Union leaders. The bill filed by the PhD students.
42 years.
They are students still. They are
like students studying in JNU, right?
Yes.
Never come out of the campus, always remain student.
Now they are pursuing PhD.
All of us are students of law till the age of 80 like that. No?
They are students.
You get it, mister. You want us to dismiss this? Enough, I think, for this issue. You understand with your experience in life, You understand what we are trying to tell you.
Yes, I understood.
So either you file a separate writ petition with regard to your grievance that we can permit. This thing at your instance, this public interest litigation is not maintainable because you are an aggrieved person. Got it? What? In this public interest litigation, the petitioners who claim that
Appellant is requested to have.
correct senior counsel that nobody gives fee in crores for an engineering seat, correct? The case is over, but we are asking. Correct?
I might add engineering and law also, madam.
A law.
I believe nowadays law has become
7 lakhs per year.
Law.
7 lakhs per year.
Yeah.
Yes. Appellant requested.
Where the TAFRC initiated action against the colleges by imposing heavy fines.
All right.
They've been disqualified. I think that our level is
Very
So they are unable to fill up the engineering seats, right? We are producing excess number of engineers and people are unable to get employment also.
only in few categories like computer sciences, they are full up. But the rest of the categories are all vacant, madam. Certainly not in lakhs.
Yeah.
There may be some wrongdoing by engineering colleges, but they are not taking in crores.
Yes, yes. Not only lakhs and well below this thing. I'll tell you this thing. This VIT, Vellore Institute of Technology charges like on your ranking, it's based.
Yes.
So if you have first, if you have scored 10,000, this thing, one son of my acquaintances got admission. His rank was some 12,000 and this rank. So first 10,000 get admission in VIT. Thereafter, there is a management quota. So he went and the fee for this thing, merit candidates is around 1.5 lakhs per year. And this, he paid, I think, 3,70,000 or something per year. So it's like that. It's not 10 lakhs.
10 lakhs is
Like in
after college, 10 lakhs is
in
their
a,
collection.
in
It's a small amount.
engineering college so reputed like VIT. So each one of this part of the India and all across its known VIT, whole this thing institution. This is off the record. Nothing to do with the case. All right. Yes, please. Okay. We have to be, Mr. Counsel, so cautious. Good old days are gone.
Yes.
Everything is being live streamed. So we have to be extra cautious, right? We can't share this thing.
There is this book called 1984. Well, it's on a lighter vein, I'm only saying.
Yes.
In 1984, the critique was against a totalitarian state. And it was said that Big Brother, a character in that book, is always watching, as my lords know.
Yes, yes.
Now I think because of this, Big Brother in democracies are also watching us. That audio or video.
No, but we are a large family, all of us, like you and judges and the bar.
Yes.
So this interaction between us on a lighter note can always go on.
Technology is good, my lords, but sometimes it may
misuse it.
Yes. Okay. Thank you. Yes.
Appellant requested to have this matter after 2 weeks, Your Lordship, item 21.
What is this matter?
Appeal.
This appeal has been filed against, and this appeal under section 19 of Contempt of Courts Act has been filed against an order dated 5/6/2020. We have read, so that's why we are writing, because third time it is coming up, twice it is coming, twice it has come up.
The second time.
Madam, don't do it. This is criminal.
Documents, Your
Criminal. 1st August we granted you time again.
We need
On
to file the
1st of August 2023, Learned Counsel for the applicant was granted time to file documents. However, once again, when today also Learned Counsel for the applicant prays for adjournment to enable her to file document. There is nothing to file document about. Your argument is that there is no direction expressly prohibiting us from initiating a fresh departmental inquiry. He misconstrued the scope and reinitiated, but I tender an unconditional apology. That's the end of what document will you file? This is all right. This is, however, by way of indulgence, 2 weeks further time is granted. We are telling you arguments also. See, such this thing. We are such good judges that we tell what you should argue. Madam, list after 2 weeks. No adjournment now. Next day.
Wait, please, my lords. My lord, this appeal is directed against an order part.
Before you proceed, the impugned email, which you say on the basis of which you got communication, is not filed.
Yes. But apart from that.
Because that we wanted to look at what was stated in that email. For you to say that it is only when we read the email we got to know about the proceeding. That has not been filed.
Very well. My lord, may I request your lordship to have it, my lord, next Tuesday, so we'll file. I'm sorry, my lord.
Where is the notes, madam?
I'm for the respondent.
Notes, my notes, nothing. Learned Counsel for the applicant prays for and is granted a week's time to enable him to place on record email.
Yes.
Email. Dated 26/10/2020.
26/10/2020 for perusal of this court list on next Tuesday is what?
Next Tuesday.
Holiday.
Holiday.
15th August. Nothing can be done about it.
2 weeks, my lords.
So
2 weeks. Very well.
22nd August. 22nd August.
Very well. Deep request.
Council has withdrawn wakalat now.
Yes, my
On 24/7/2023, counsel for the appellant has withdrawn wakalat. Today, when the case is called, none has appeared on behalf of the appellant.
Yes, my lord. Yes, my lord. Petitioner. Appellant.
Whether it has undergone the procedure to the
Have you gone, taken permission from the committee to appear yourself as person?
14% committee is there, no?
True, my lord. But once the number has been done,
No.
they said.
That is the technique that is being used by many councils.
I did not. I never.
Case through advocate and then.
All right, has withdrawn wakalat and then 14%.
I may be referred.
14% prays for accommodation in order to enable him to produce a certificate from 14% committee. C certificate, no? But something. Certificate for 14% prays for time to appear before 14% committee and to seek a certificate and to get a certificate from the 14% to enable him to address this court in person. List after
2 weeks. 2 weeks, my lord.
2 weeks.
Thank you. I'll answer this matter before my friends.
Why did they go to same after? And period is not mentioned.
Yes, my lords, in this matter, I am representing the respondent members, 2 my lords. This matter has to be listed on 23rd. In fact, your lordship, the item 26 was listed on 3rd August, and my lord, it was urgent to 23rd August.
But why should you do like this? I mean, you could tell us.
My lord, the difficulty is, my lord, the person.
In 613, there already a date of 23rd August given.
Yes.
It was the whosoever made Mr. Jaya Krishna.
Yes.
Should have told us that the 613 is listed on 26 or whatever date. What date? 23rd.
23rd August.
Don't do it. Not fair.
I filed a writ appeal.
You did not know.
720.
Along with WA 613 part
It is listed
2023 on 23rd August 23.
Next item is 613.
Both of them have been advanced, chief. They have advanced both the matters. But see, he's paying for it. But see, you merely by making a statement because we rely on you, you got the case listed, which was fixed for 23/8 today. And today you got it listed. You are saying for adjournment that it be taken up for 23rd August. Why don't you argue?
My lords, I am representing the respondent number 2. My lord is not feeling well. He has informed me that item 26 was listed on 3rd August.
Don't misrepresent, right? We will remember you. That you are a counsel that who doesn't make correct statement of fact.
No, I'm sorry, my lord. I did not appear on the last occasion. My colleague appeared.
Whosoever appeared.
So one more thing. I may say, but on the last occasion, my colleague represented that matter can be taken up along with this writ appeal.
So, Mr. So and so, madam, you are appearing for R2.
Respondent number 2, my lord.
R2 prays for adjournment on the ground that the arguing counsel, Mr.
Venugopal, senior counsel Venugopal is not.
Is unwell. List on 23/8. Along with WA 613. Yes.
I have to represent Mayur Mundra in this matter.
Yes.
Lordship may recall this matter had come up. It's about
yes. So,
filing an undertaking to be present before the
yes.
court. I request your lordships to have it tomorrow. It's being filed in the court today.
Tomorrow.
Tomorrow.
So I think if he gives an undertaking, that should
solve the problem.
Yes.
But I have a little bit more to say in this case.
All right, we'll hear you tomorrow. Senior counsel prays for short accommodation to enable him to make a statement in the light of observations made in the order dated 3rd of August 23. List what date? Tomorrow is what? 8th August.
Obliged.
Item 28, revocation.
Kindly pass over this matter, your lordship.
No pass over. Appeal. This Satyavati Tandon last date of hearing, senior counsel should have been here.
Is on the way.
No, nothing. This, what is the name of senior counsel?
Prabhakar Sripada, your lordship. Designated.
Pass over.
Much of.
No adjournment. Don't come in pass over round if you don't want to argue. It will not be adjourned. If you don't come, order will be passed.
The practitioner.
Nothing. You are trying to extract the admission from them, which they don't want to give.
Special GP, that he will give some concession from the.
No, they are not giving concession, nothing.
EP similar clause was there, they have given.
Sir, we can't, it's a state prerogative.
No, in the prospectus of YS.
No, what case itself, Mr. coming up before us?
University has to do it.
The university of AP state has given.
One thing, before you argue, today is the final day of this case in the court. I have been here only for 11 days and this case has come thrice. 24th July, 25th July, 2nd August. So argue. So you can't be, because you are not challenging this government order. So interpretation wise, they say that CRPF doesn't fall under cap category. You know it, what is it? They're trying to extract admission from others, which they are not willing to give. Yes. All right.
That's the only thing
in this, mark the presence. Oh, this all right. We granted indulgence to you in the fond hope that something can be worked out, but it's not. In this writ, mark the presence in this writ petition, comma. Yes. In this writ petition, comma, the petitioner inter alia seeks a direction to the respondents to permit him to participate for admission to MBBS/BDS course under the Children of Armed Personnel within bracket CAP category and to permit him to participate in the madam, in the beginning you write permit him to participate in the counseling scheduled to be held between 25th July 2023 to 4/8/2023 for admission to MBBS so and so under so and so quota, right? Paragraph. Admitted during the pendency of the petition, the counseling has already been held. The which geo? The government order dated. Which is the government order, Mr. Which provides that this thing, the regulations. What, Mr. What is it?
Page 35 minutes.
What is it?
Regulation.
Regulation. The regulation. Which regulation?
The details of reservation.
Regulation 1 of the regulations. No. Regulation 1. No. What is this? The regulation 1 of the regulations framed by the Sainik Welfare Board provides that the children CRPF is not included, right?
Yes, CRPF.
That
is not coming out
under the expression armed forces personnel used in the regulation, comma, a person belonging to CRPF is not covered. Full stop. CRPF/BSF is not covered. Full stop. The petitioner has not challenged to chosen to challenge the aforesaid regulation. Therefore, in the absence of challenge to the regulation, no relief in this writ petition can be granted to the petitioner. The same is accordingly dismissed.
Your Lordship giving liberty for it.
What liberty? Now, so all over. 4th August is gone, right? What were you doing, Mr.? 3 times. You did not even apply your mind. What? Yes. This was 29, madam. This was 29.
That is my lord.
34, I think is 05.
Yes.
In this matter, my lord, I need to file one more GO is there, my lord, issued by the state government. That I recently got it, my lord.
You are for the petitioner.
I'm petitioner 30, my lord. Item number 30.
Learned counsel for the petitioner, praise warrant is granted.
I need to file this GO.
How much time? Understood.
Yes, madam.
How much time?
Tomorrow I will file it, my lord, by taken up in the next week, madam. Tomorrow I will file it.
Place warrant is granted a week's time to enable him to place on record certain documents. List up thereafter.
May be permitted to better affidavit also, my lord. Permitted to with affidavit, my lord.
Withdraw.
Yes. Additional affidavit, my lord.
You can file. With this, yes.
There is a connected writ petition, WP number 2033.
No, don't time in 35 has been called.
Sir.
35. Password. Password.
Nagendra Reddy, he is Nagendra Reddy.
Who is appearing in 35? No, none. You are not appearing, right?
31 million. I'm only appearing.
Huh?
I am only appearing.
Then why did you go away? It's not our case.
Confusion.
So, Mr. Yes, what have you challenged?
No, there is a connected writ petition.
No, connected 35 you tell us.
Yes, madam. In this case,
how connected will be decided.
Yes,
it is repeatedly being adjourned.
Yes, madam.
What have you challenged?
Yes, madam. The Pollution Control Board, madam, imposed the
21/6/2023 order.
Yes.
The directions up to page 15. You know it, mister. You are pretending as if it's so you are opening the file here, right? Page 17, 18. These directions have been issued under section 33A of the Water Act and 33A of the Water Act and 31A of the Air Act.
Yes, madam.
Appeal against both the orders lies under the Act.
Appeal lies, madam, before the appellate board, madam. Appellate board is not functioning, madam.
Where have you said in the affidavit?
No,
that appellate board is not functioning.
After filing the writ petition, madam, only I verified, madam.
So after filing the writ petition,
you go because even before all this, board was not functioning.
No. This is National Green Tribunal.
National Green Tribunal, madam, does not arise this appeal because it is an order passed by the Pollution Control Board, madam. It is under section 31.
Mr. These read 33B. 33B. Any person agree?
31.
These directions have been issued under 33A, correct?
Any person agreed by an order or a decision of the appellate authority. But by here, madam, it is not appellate authority. Your order is 31 years. Your
33A has been issued under Water Act.
C, please read 33B, C. Direction issued under section 33A by a board on or after the commencement of NGT.
You cannot get away by NGT does not exist. You are trying to tell us.
NGT is existing.
File an appeal.
Conception. The Supreme Court entertained some.
No. We are all deciding. We are relegating everybody. You forget about everything else. That's why these cases are repeatedly being listed, and you people are not appealing.
This is the second.
We are asking you. You are concerned with your case. We are asking you this question. Why should you not file an appeal under 33BC?
Your words, my request for tomorrow. I'll
Sorry. It is being listed adjourned.
Last.
No, Mr. Nagendra Reddy, 3rd August, you appeared in pre-lunch session. Thereafter, post-lunch session, you did not appear. Therefore, we have listed in 7th August. There is a limit to everything. Limit.
He appeared and asked for a
passover, and you did not appear. So you have to be, as an officer of the court, you owe a duty to be fair to the court at all times. This is not the only case. We are dealing with those cases also. You file an appeal, correct? In this writ petition, Mr. Nagendra Reddy, learned counsel for the petitioner, in this writ petition. on. No date. You want an adjournment? Fine. Learned counsel for the appellant prays for adjournment to enable him to prepare the case and argue the same list after 2 weeks.
Connected appeal, you last was posted to 14th August for payment of money. The connected contempt appeal of 2023, you last granted time till 14th for payment of money. Last kindly put it on 14th.
Learned counsel for the appellant prays for adjournment list on 14th August.
I'm deeply obliged.
Next. Yes.
I'm representing counsel for appellant's lordship. Counsel is suffering from conjunctivitis. Requesting 1 week time.
Learned counsel, what's your name? There is nothing in the case. Learned counsel for the appellant.
My name is Karuna.
Prays for adjournment on the ground that the arguing counsel is, who is arguing counsel? He is unwell. List after 10 days.
43 and 44 go together.
43 and 44. Yes. 45.
I'm appearing.
Lordship, I am for petitioner.
My lord, I
43 and 44.
Keep here, no, like proper.
My lord, I request 1 week time may be granted for it. I'm appearing for the UPSC, my lord.
Counter. DOPD has already counter.
Just recent.
Want to file counter?
UPSC has to file for counter in this case, my lord, and
Which
recent
respondent, Mr.
second respondent. my lord.
Learned counsel for
I am for
respondent.
petitioner.
Respondent number 2, praise fund is granted.
2 weeks time may be granted.
Don't take 3 weeks. Don't seek thereafter. 3
I'm
weeks
obliged.
to enable him to file counter. This
Obliged.
thereafter.
Much obliged.
Yes.
I'm item 50 million connected with what?
Item 50, yes. Happened. You could take out.
Yes.
So that you speak better, right? You are audible to us. Yes, please.
It's connected with 47 and 40.
Fine. So
This matter is coming up for count.
do we need to tell you what are the facts of your case?
Yes,
You
fine.
don't know.
In this matter, my lord, the TSPS issued a notification to fill up the posts of fiscal directors. And we challenge the notification, my lords. And
Fine.
without
Yes. These people don't. Petition is admitted for hearing. Let counter, if any, on behalf of respondents be filed within a period of 6 weeks.
One submission.
It's all over. Yes. You didn't say anything. Yes.
Item 50, I may be permitted to apply for the.
You want to withdraw?
No, I want. I may be permitted to apply for the application. My application was not accepted.
What accepted?
That's
This
it was gone.
Petitions have been admitted.
GO. Challenge is to the GO.
Yes.
So we will consider whether that condition prescription of 2 degrees, one MA, regular MA, one
Yes.
with physical education is correct or not. That is the only issue.
That's in item 47, we have incomplete petition. The incomplete petition was filed. Right?
Any objection to incomplete petition? Who are you?
And for the Millard, candidates having double PG Millard,
Because we are affected,
Heard on, madam, which case?
we are
47 heard on IA. What the reasons assigned in the application duly supported by an affidavit. IA is allowed, let that will be amended, whatever registry, whatever, within 2 weeks.
Okay.
Yes, next.
57 CHR.
Yes. This is Air Act.
Strong crushing. Is also the power should have been used for secure.
Password then. Password.
Implement your consent for application, but he is continuing getting.
Should tell that in. Yes, password. Next. Yes, madam. Yes. Affected for 43.
Included and
Yes, yes. In this petition, the grievance of the petitioners is that by impugned GO dated 30th/4/2023 and 26/2/2023, you say none for the petitioner. 26/2/2016, services of contract employees Yes.
L. Ravinder, G. Ravinder.
Madam, 63, you are appearing? Yes.
RBI may not ask to file counter, may not. RBI may not ask to file counter.
As to file counter?
Yes. Nobody,
notice has been issued.
Notice issued, may not, nobody will enter into appearance.
They have been served, right?
Issue notice to respondent to RBI and list.
Served. Madam, served. RBI served. Await service of notice on Reserve Bank of India. List the petition as soon as respondent number 2 is served. Not served, madam.
Not served.
RBI. So we have adjourned. Next. 64. Counter is awaited.
I'm representing for respondent number 4, sir.
Now what? How can?
Matter had come up.
This thing.
Similar matter had come up on Thursday or Friday.
Stop construction. What? How can this be done? Who appears for Lokai?
My lord,
Pass over.
I'm representing for respondent number 4.
Pass over. Pass over. Pass. Because it's past 1:30. So next 65 you call. Yes, Mr.
Status report was supposed to be filed.
Status report file.
Status report not has to file by the state government, not I am appearance of the archaeological department. All the heritage structures may not mentioned in the petition.
You filed everything. Then Learned Counsel for respondent number 6, praise for is granted. How much time? 2 weeks time to enable him to file counter. 66.
Affecting the stability of the report.
Who appears?
Status reports have been filed, by the Archaeological Survey of India.
All right, we take it up in as password. How many passwords, madam? 4 or 5? 5, 6. And then we go ahead with the hearing part now. Hearing. Let's see how this that we had 2004 appeal, 5 appeal which we were hearing this. How this is generally 2018 has come as past 4 and
66 to 68.
Parents four and 5.
all right, so we begin final hearing. We are so happy about that today finally. Oh no, Mr. Come in the afternoon.
One of my best friend passed away yesterday. People spoiled that I need to participate in the funerals. My item 7 is password, Miller. Instead of password, kindly add it tomorrow, Miller.
7?
Yes, Miller.
What is 7? Give file. Environment protection.
Tomorrow,
environment protection. What is the matter?
Matter is Miller, service matter, Miller. Though he has final seniority list has been issued.
1 second. We were, at least when I read the bundle, it was a shokan. It was a notice asking for objections.
Already objections made, Millard.
But consider there is no final order passed.
Yes,
the issue is 21/6/2020.
But Honorable Supreme Court categorically stated that, Millard, once seniority list has been final, after 10 years that cannot be revised. The judgments also have excused.
No, that can be said in your reply.
Yes,
will be, if they don't consider good ground.
I have stated it, Millard. Kindly have it tomorrow, Millard. I will satisfy your lordships. Petitioner is the scheduled tribe implied.
No, nothing to do with petitioner. Who is he?
Yes.
Brother has pointed out the legal issue, right?
You
know the answer, but still we will hear you tomorrow.
Yes, those are all I've already mentioned in my objections.
7 list tomorrow.
Oh, press.
So you should have been here, right, when the case was called.
Deeply impressed.
My lords, I forgot
You were appeared online. Right.
My lords, I apologize. In the morning, I had mentioned with respect to 58 to 62.
Then you realize that you are not appearing in that case, right?
No, my lords, this 58 to 62, my lords, the batch had made a mention for a new matter to be tagged along. The rest of the matters, directions were given. That's why
That's why you shouldn't get it right. You don't know what orders will be passed, and you also, if you are not present, something is passed and your case is gone without hearing you. Shouldn't do it.
We were there, my lords, but because the matters, I was just here, my lords, but because.
So what we have done, we don't know what we have done.
We have directed them to include the affected party.
We have directed them to
include the
affected party.
No, my lord, in this case, my lord, I'm instructed to appear. In fact, my lord, we have implemented.
So then the petition is admitted. Petition is admitted for we have understood that in contravention of law laid down in Uma Devi and contravention of Rule 9, their services have been regularized in same order. Admit notice. His case also. Lunch motion, learned senior counsel for the petitioner heard on the same order in which we have written contravention of Uma Devi and Rule 9. Petition is admitted.
In IA1, my lord, we have prayed for my lord, an order from this honorable court saying that the respondents, my lord, whom we could identify and make them party, may be declared as representative capacity, my lord, for all
That
those.
we will consider. Issue notice on that IA also.
IA1.
Which IA?
IA1.
1 of 23.
Yes.
Right?
Subject to lordship's leave. Item number 70, my lord. I would like to argue this matter, if your lordship.
So we are coming back. It's
very well.
See the time. You want to argue now?
No.
We are hungry.
2:30, Lord. Whenever it reaches.
Sure. We're coming back. దాని తర్వాత ప్రాసెస్ lunch motions we have given. You know, this item one, lunch motion is over. And what is second? Second is medical. Ah, yes.
Petitioner is a student, a minor, represented by our father. My petitioner studied in Hyderabad from 2011 to 2020 for a period of 10 years.
Declaring that we will exonerate from the principal. Other than to participate because 10 years is just protection. Counseling for when company will be the
Counseling, Mr. Ravi, counseling is over? No, web options.
When? From which step to which? 25th July to 4/8. 4/8 to 7/8 yesterday. 6/8. 4/8 to 6/8. It's over. And what is the next date of counseling scheduled for? Options. So you seek instructions, will learn it. Day after?
Day after they will file.
No, but this is, you are challenging, we can't declare GO unconstitutional today itself.
Suppose if they are not challenging, I cannot make that the incident. You are not saying, I will argue facts the case, you are not saying, because they are tomorrow they will file. But in Hyderabad, instruction tomorrow, you are not.
He is saying no.
We will not be, we will not, but in Hyderabad, we can take instruction.
No, so what facts you think? What is the challenge to GO on what GO provides?
See, the facts are,
Ah.
the student of 2011 to 2021, she completed the class 8. Because our parents are then there will be 2011 to 17, his father and working.
No, you said 11 to 21.
Student was studying here.
Ah.
2017, father transferred to the
17.
Sir. Then mother requested some school education. Mother is also officer, she requested government some of this to complete the education. The government permitted her. And the 2021, 21 mother transferred to 2021 mother transferred to
No, we want to know whether candidates are treated local on the basis of their parents' posting. So once she has completed from 11 to 21. So it doesn't make any difference whether their parents are posted in Tamil Nadu or wherever.
Parents are 2010 to 11 for 10 years. She studied.
So that's enough, right? Not enough.
2020.
No, because we have not read this file. That's why we are asking, maybe according to you, some questions, or permit us to read it, then we will hear you. Schooling in Hyderabad to transfer, doesn't matter, right? 10 years plus 2 years.
In 10 plus 2, in 10 plus 2, 12 years. 10 plus 2, how many years is, what is the requirement for being considered as a local candidate?
Qualifying examination 4 years. But 10th class 20 years. But intermediate qualifying exam because of mother transferred from India. Under that, mother taken to Chennai. In Chennai, she completed.
That is plus 2 she completed in Chennai. Plus 2 in Chennai.
Situation I completed British certificate. I transferred from mother not transferred.
I can't say government. Senior, please to show us that local candidature. Can you take the page number? Page 18 pages. Yes. But page 18, they do. Page 18 is the GO, which page 20, man. Page 20, local area. Well, I request you, your worship, the B. Local candidate, a candidate for admission shall be regarded as a local candidate in relation to the local area. If he has studied in education in the local area for a period not less than for 4 consecutive academic years, ending with the academic year in which that year and the TSHC first appeared for the relevant qualification. This is what this is. This rule says I can study anywhere in India, but I must be present in Kerala. Then because situation I am expected local candidate. B. So I will different situation because parents are having the service.
So she does not fulfill the requirement of investment immediately preceding 4 years. But so that's the this is then motive purpose. You know, as we struck from happens to victim. It didn't. And what is the important? This counseling is over. What he was doing, no, first remotion is over. Why is the petition today 7th August? So why this thing? One query: why did you file the petition today? This you are aware 4th August to 7th August counseling over all this. Why? So, Mr. As we have understood from whatever we have read in this thing, just a minute. Just a minute. So, your case is that you don't fulfill the requirement of you say you challenge the government order.
Second, I was so
So, 2nd August, when today is 7th, 5 days delay.
Second, they are not idea of considered. Then they say,
Mr. Under the existing rule or this thing, you are not entitled. And that provision is not struck down, despite that you want admission to educational institution. And please appreciate our this thing query that first round of counseling is over.
And the petition submit for same fact. The petition submit right from the first time at private stage, only the date of the but for we the petition that of the Maharashtra, about 4 years ago. This petition being acquired from statement of her father.
What do you say? We have read. We have read it, Mr. We have read it. No. We just trying to tell you. We have read it. Please do not read. We are asking for his. No. The idea is to save time. Senior counsel, nothing. In when I was a youngster and I joined the bar, second appeal involving the question whether it's a lease or license. I have heard argue. I have seen senior counsels like you arguing for 1.5 days. Now that sort of luxury we can't afford because of the pressure on us. We can't afford like hearing this case for whole day. Yes. Learn it. Senior counsel for the petitioner. Which case? 28.
Wait, please, Your Lordship.
Yes.
Sorry for my absence.
No, no,
Morning.
fine. Yes.
My Lord,
yes,
very short point raises for Your Lordship's kind consideration, my Lord. It's only a technical point. The point being whether the secured creditor, my Lord, can enforce, my Lord, his rights under Chapter 3 without registering the security under Section 26D of the, my Lord, Securitization Act. Section 26D, my Lord, you may just trouble Your Lordship once with Section 26D, my Lord. Says.
No, so your colleague had appeared, we had put the query to him twice. What happens to Satyavati Tandon and the latest decision of Supreme Court in 2022? All these grounds are open to be agitated by a person aggrieved by a measure taken under Section 13(4). You are addressing us on merits. Supreme Court has deprecated the practice of high courts entertaining this thing. We are for a moment, we are not saying that you don't have a case on merits. We are only on the question of alternative remedy. If there is an interim order in your petition, that will continue till you file an appeal.
Or may I make a small suggestion? May I make a small suggestion? My Lord, my application is pending before the DRT.
What application?
This securitization appeal, my Lord.
Appeal is pending.
Pending.
Already. Oh.
It is pending. In the pending matter, I filed an interlocutory application. In that interlocutory application.
Who appears for the bank?
I beg to appeal.
So what's there's no purpose in keeping this appeal pending, a petition. He would like it to remain pending for 5 years. We don't want, you should agree. We will direct the DRT to decide his appeal within 3 weeks. Till then, interim order shall continue.
Very well.
Mark the presence. In this writ petition, the petitioner has have been, we would have felt happy if you would have said this.
I'm obliged.
Which was the item 28? No, this was only 28. Which is 50?
My lord, sorry for I was not at that time. So writ petition filed by the petitioner without issuing any mandatory notice.
Mandatory notice, where is the permission to run the industry? First tell us.
Alternative remedies.
Millard, I'm for the respond number 5, Millard.
Wait. We are asking a query to you. You are eager to answer?
No, Millard, it's intimated to represent.
When the court is not putting questions to you, you should be happy and comfortable, right? I always used to sit down as a counsel that is there. He knows what we are. Where is the Mr. Permission?
Permission was granted and I expect even 12 and 14 pages.
Date.
Page 12.
No, date.
Dated on 23/7/2008.
23/7?
2008. But thereafter,
just a minute. So, what, read para 6 of this order.
Yes, Milan, it is for period of 5 years, but thereafter there was a show cause notice was issued by the.
So it expired when?
Yeah, it's by 2013 it was expired. Thereafter.
Then did you apply for a consent afresh?
I was given an application thereby already the show cause notice application. Thereafter I replied for that, and that was considered. All of a sudden, the basing on the writ petition filed by the.
Where is that order? Consent. You did not have a consent. You were running a plant, and this is an order under section what? 31A.
31.
So appeal lies under
28.
28B.
Of the water.
Not under 20. If order is passed under 31B, the logically speaking, it has to be a provision next to 31A.
33.
How it can be 28?
33.
Don't say, if you don't remember, don't say incorrect facts.
That order under section 25, Millard. Closure order, challenge the closure order.
Now, 25.
That is page 27 and 29.
28 is State Air Laboratory.
Water Act. This reputation challenging that closure order issued by the court, Millard, for non-compliance of the order.
Which act, Mr.? This is Air Act.
The last one. Shall apply for operation of the room before doesn't have consent for operations.
So where is the consent for operation, Mr.? Is subsisting. Come to page 14, clause 7. This order is under this thing, air pollution. He says water. Air pollution around India. He says Water Act. You are appearing for Pollution Control Board, right? So at least you should know under which provision you have passed an order. According to para 10 of this order, it is under Air Act. You are saying Water Act. If we have to begin by telling you which provision, Madam, Air Act. Which I'm going to give that.
31A of Air
Act.
31A of
31 or A. So please answer, where is the consent?
That's what, Millard, I given to
Better withdraw.
Consent was given.
No, don't, Mr. We are this thing putting you to notice. Don't invite a finding from us whether or not consent. In fact, it's not there, right? Consent is not there. You are carrying on, and it has been closed. So you withdraw this petition, take recourse to the remedy of appeal, That's the better course. If you argue, then we will have to say that no consent.
Your Lordship, may I please, I will take.
In this writ petition, comma, the petitioner have you filed application?
I will file.
Huh?
I will take instruction.
Then
I will.
anticipation, right? You don't
no,
no, it's like naming a baby before he is born, right? That is fine. File an application, and if they don't decide, then perhaps we can. He will decide he will decide your application under Water Act. If you filed under the Air Act, he will decide under Water Act. Huh? Mr. What the order itself says, Mr. At least see that. It's under Air Act. See that. Yes. This was 58, madam. 56. This was 57. 57, no, previous. Now what? How many cases left? Yes. Counter. This Lokayukt. Who appears? Lokayukt has been served.
Standing comes for Lokayukt.
So then how can you direct stoppage of construction with provision of Lokayukt Act?
I'll take it out tomorrow, my Lordship.
You can grant injunction also. Lokayukt can grant injunction. Status quo with regard to properties shall be maintained. That's the question.
I'll take it out tomorrow, my Lordship. Accounts.
Why tomorrow?
Senior counsel is out of it. We went to lower court, my Lordship. I'll take it out tomorrow, my Lordship. Counsel will answer.
Not tomorrow. Everything can't learn it. Counsel for the petitioner. Why he is not well?
No, my Lordship. He went to lower court, my Lordship. Fell up in the lower court, my Lordship. Morning he was present, my Lordship. But
no, Mr. Tomorrow you will appear before Supreme Court and say that he is busy before learned civil judge arguing OS.
No, my Lordship.
What is this?
No,
do you understand this? This is first court of the High Court. And you are saying this that he is busy before trial court. What is this? There has to be limit to everything, right? You can't make a submission like this. You say not available, understandable. Don't say anything further, which embarrasses you and senior counsel. Is he a designated senior counsel? Then he doesn't know that what is the distinction between trial court and this court.
My apologies, my Lordship. But my Lordship, just now we came to know that my Lordship, this case was listed today, my Lordship. No, office was not served on me, my Lordship. That's the reason, my Lordship.
You understand what is the query put to you by us on the legal issue? Apart from repeating that he is busy. What did we tell you? How can you issue, you being Lokayukt, how can you issue a direction to stop construction? We are finding an answer to this issue, right? You answer that. The issue involved in this, the validity of the direct. What, mister? Should you not say the moment case is called that I appear for so and so, I want time? Your notices are issued. What is the, delete everything? List in the next week. What? What are we saying anything unreasonable to you? Still looking at us. What?
Sandeep, sir. The matter is called, you should stand up and say, I am appearing for third respondent. What do you want? Whether you want time or what do you want to say? This order of Lokayukta can't stand. That is what, and similar matter had come up on Friday, Thursday or Friday. Friday.
Granted interim order.
Same parties. Parties are also same.
It has been allowed.
No, we have posted to tomorrow. This coming Friday, we have listed that to Friday.
So madam, list on Friday.
Just verify the same matter.
Say something. You come here to argue cases, no? Or to look at judges. When it is called, just stand like this. We will pass otherwise. Record your that don't want to argue anything looking at the court. Yes.
So the matter which was taken up, respect of Golconda Fort minutes.
Yes.
But Golconda Fort is a centrally protected monument. What has happened is, with respect of 27 other monuments which are in the state custody, we are required to file a status report. I had filed a status report earlier, indicating that the expenditure will be 38 crores with respect to undertake the repair works in respect of 27 other monuments which are state control. But I also filed the present status report, which is a return on account of wrong cost title being indicated. I would require a week's time.
So repair work of how many? 28?
27 monuments which are under state archive. State archive.
And what about this thing? This is Golconda Fort is must be ASI.
In this matter, I request 2 weeks. I'll count.
2 weeks to file.
Yes. In the state of 67 and 58. Do matter. Not 58, just already filed.
Where is the order?
Item 66, not 171.
Yes.
Order dated 4/7/2023, Manu.
Yes.
Yes.
In Bill 171, we have already filed a report, whereas in Bill 203 and 253, I request that.
It has to be, I mean, like, there can't be two opinions about it, that it has to be protected and preserved, right?
In fact, no construction activities
can't carry out.
Status report has been filed by respondent 123, that is central government, on 7th March 2022.
You have filed this thing.
We are filed on 7th March 2022 one status report.
Yes, but then that is in the 121, item number 66.
So this matter they must have said.
Item 66, I have filed.
Protection of Golconda Fort. Right?
There are other two
The issue in this petition pertains to preservation. Learned TSHI for Union of India.
Same.
68 also same.
68 blood, I am appearing for R8, that last case blood, the son report directed me to file an affidavit blood, the status of blood Ashokana.
What you are digging the port?
No, I'm taking.
It's lighter vein, Mister. Good that you smiled.
I only wants to protect the port.
Fourth, you also want to protect, right? So you should be with these people.
No, Ashar Khan, you lots of kindly see the photographs, compound wall and other internal structures. Totally damaged, but they are not taking any steps.
So 2 weeks we are granting, give a date.
Yes.
After 2 weeks, we'll give a date. 22nd August. You respond, Mr. by this time. Yes, madam, you wanted to say something?
No, my lords, the issue is addressed.
So, with passage of time, you find solution to every problem. Wait. Yes, okay.
I beg to appear, Malad. This matter, Malad, my friend has filed just for Malad, IA number 1 of 23 is a petition to fix an early date because this intra-court appeal is 10-year-old.
Yes, of course.
And 2013.
No, we can in fact start. This is for hearing only.
This is for hearing only, Malad. In fact, Malad, may I just say this? This case was heard and judgment was reserved on 26/7/2022 by the revision bench. Then judgment was not pronounced, matter was reopened for further hearing. And this writ petition is of the year 2006, judgment rendered in 2009, appeal filed after 4 years, 2013 delay condoned, and this writ appeal is pending. 3 of the writ petitioners have left this planet. They are no more. State is the appellant now in this case. And the controversy is this, certain survey numbers land, state claimed as Jagir lands. Learned single judge said that you have to go to a civil court and file a suit to establish your title. Because that cannot be adjudicated either by the joint collector or the Mandal revenue officer, whom the state was pursuing. So a writ of prohibition was issued against the joint collector from proceeding with the claim petition filed by the Tahsildar about adjudication of certain survey numbers of land as to whether they are Patta lands or Jagir lands. And the learned judge has relegated the state to file a suit. There is no judgment, Malad, except the fact that the state is relegated to file a suit. This is the order under appeal.
Short time I require, Malad, because matter has to be heard finally. 2 weeks, Malad.
You would ask your colleague to know what 2 weeks, Mr. Give a short list of dates we dictate here only itself. Nothing we don't want to keep it pending.
Written submissions are filed, synopsis is filed, part of the file.
Oh.
Yes, by both sides.
This is IA number?
IA number 1 of 2023 is the petition to fix an early date.
Flag. What written submission, etc. You put a flag in the record. So date, Mr. Next week sometime.
Next week.
What date? This week itself also like this. Nothing we has to.
Tuesday.
No,
What do you say?
Well, it's matter is this, that they are asked to file a suit. That's all.
But we are ready to decide. But your friend is seeking time.
They had the condemnation of 4 years delay in filing the writ appeal and 10 years pendency of the writ appeal. 14 years.
This has come before this combination first time. So, and so we'll fix Tuesday's what? Tuesday.
Next Tuesday. Next Tuesday, we are holiday.
Tuesday, I'm told.
Hey, you are asking for conveniently for next Tuesday, which is a holiday.
Wednesday. I've just reminded of the date, it's 15th August.
So it would be 14th August, right? 14th August.
He wants Wednesday, Malad, that is day after tomorrow.
Next week.
Then 15th August is asking.
That's why we are telling him 15th August.
I'm sorry about that.
We want the parties to celebrate the Independence Day.
Yes.
Either state and citizens also.
Monday or Wednesday.
14th.
Either Monday or Wednesday. 14th or
14th is fine with you, right? Heard on IA 1 of 2020-23, taking into account the fact that this Can't say that, no, I am not. So next date, if Advocate General for some reason is not available, you will argue, right? This is like this 22 matter.
Appearing for the respondents, respondent 1 to 3.
This IA is for additional material petition, we can accept.
Additional material we will accept.
Well, as directed by your lordship on the last occasion, I have prepared the list of dates and events. My
No,
good
this
friend
is
Pranav was also
Mr. 22 appeal petition.
Pardon?
2022 petition.
It is not for hearing, but only notice before admission was given. It is not even admitted.
All right.
Then may I state the fact?
Third on the question of admission, petition is admitted.
These are the facts.
Admitted for hearing.
Pardon?
Admitted for hearing. You said not even admitted for hearing, admitted for hearing.
Very good. Now, may I argue for the interim order? I am seeking an interim direction to measure the
This is for hearing. Let the petition be listed for consideration of IA 1 of 2022. What date?
I am for the respondent number 8 and 9.
After 4 weeks, my lord, because I am out of station.
After 4 weeks. Correct. After 4 weeks.
Very well.
Yes. Please give, you, madam, staple it and keep it in the, otherwise it will be misplaced, right? In my copy, you staple it. Don't keep it inside, we will never know where is written. Put a flag there,
Right.
written submission. Written submission, put a flag and staple it. Yes, next, 71.
Well, this writ appeal has become infructuous.
Oh.
Your lordship may dismiss it as infructuous.
All right. Learned senior, this intra-court appeal has been filed against, yes, madam? Against
WP number 2
against an order dated so and so. Which order, Mr.
17/3/2004.
Against an order dated 17/3/2004 passed by learned single judge in writ petition by which what has happened?
Writ
By
petition
which,
was dismissed.
by which writ petition preferred by the appellant
Appellant has been dismissed.
appellant has been dismissed. Paragraph. Learned senior counsel for the appellant fairly submits that the
Cause in the writ petition doesn't survive.
that cause in the writ petition does not survive for adjudication on account of efflux of time. Paragraph. In view of aforesaid submission, the writ petition is dismissed. Writ appeal is intra-court appeal is dismissed as infructuous. Yes. Yes. This is right. Now, so apart from COP category, you are arguing something worth hearing. Yes. Lighter vein, Mr. Yes, please.
The appellant before your lordship is the writ petitioner, correct? Let's writ petitioner filed writ petition filed seeking exemption of payment of excise license duty, mallet. But dismissed by the single judge.
So what happened to 8244 of 94?
That is confirmed.
Then which writ appeal?
But there is no writ appeal filed against that.
So then this order passed in 8244 of 1994 has attained finality.
Has attained finality.
Fine.
Mallet, but both are government only, mallet.
Whatever. We don't. Yes.
Mallet, I am into power generation, mallet. I am not required to pay
No, but
license.
please understand. We cannot adjudicate to open. Principle of parity applies. Right? What is the prayer in the petition? Where is it?
That demand raised by the.
All right. Yes. Or whatever. Final order. How do you write? I don't know. You do it.
Licensee as well as a captive power generation.
Where is which paragraph? The petitioner is
Parties are different, my lord. Properly, those the amount involved might be.
So then if you want to argue, then argue. You are not arguing, right? So
let's.
You said we asked you whether it has attained finality. You said yes.
Well, it's in the context, in the sense that
No, was there an interim order?
There is an interim order. Not to take coercive steps.
Oh. So how much is the amount that?
Let's say translated to crores, 6 crores.
No, so what are you waiting for, Mr. For an invitation from this court to argue? Then please, it's your opinion.
It's 4 crores 59 lakhs. Let's is the demand.
Then please argue how you are not liable.
Let's appellant.
Don't write, madam. First paragraph. This intra-court appeal is filed against an order dated so and so. Then facts giving rise to filing of this appeal briefly stated are that petitioner is so and so, whatever.
It's the power generated balance is balance is given to the employees of the company. Therefore, there is no element
paragraph
of.
Is a petitioner so and so. Is a captive power.
I am a licensee under section 2B, my lord.
So, also supply to and argue that this is fine. Hearing apart from that, they are giving free electricity. This is 2003, madam. 48 Act.
1948 Act, Electricity Act 1940.
Not ready to opening reading here. I'm not ready, right? Opening reading the papers here. Your case.
Since I am not, there is no element of sale in the process, my lord. Therefore, I am exempt. I should be exempted from payment of excise duty. Electricity duty is the principal contention, my lord.
What is section 3, Mr.? What is the incidence of duty? How payment of duties are tracked?
Well, if I am getting money from ballot, then I am liable to pay duty. There is no element of sale.
Shall we say that you have not even told us what is under which provision a demand has been made? Opening papers in the court and telling anything one sentences. This is for argument in final hearing matter.
Page 36 is the demand notice.
Page
36.
Page 36 is the demand.
No, but Mr. Harsha, tell us one thing. Your application for exemption has been rejected by the government.
Yes.
Have you challenged that proceeding? Without challenging your application for exemption rejection by the government, how can you challenge the demand rate, which is a consequential?
Under which provision exemption?
Similar.
Section application that was rejected under since where right under difference considered a negative by the G. Exemption for me. So that was rejected. So once that exemption was rejected, when is rejected? The government memo. 12/6/14. So as a consequence of that,
This demand has been raised.
So under which statutory provision they are liable to pay excessive section?
There is one, for the circuit breaker means they have given similar benefit.
Okay.
So these people also apply the same benefit that was created.
So madam, what have you written? Read. No. Beginning. This intra-court appeal. No.
One second. Under this provision, the application was seeking exemption from payment of electricity.
Active by
1939 Electricity Act. Electricity Duty Act. Electricity Duty Act. In fact, if I recollect correctly, it was 1939. I just give you one.
It was rejected. No?
This was rejected. One second.
He just told me it did.
It's in 2000.
12/6/2003. Thereafter, a notice was sent.
There are improved notices.
Notice on 8/7/2003.
The memo was rejected on 12/6/2003.
Yes. Madam, delete everything. Right. This intra-court.
Thank you for the.
This was 32. No, but prior to the under which provision they are liable to pay electricity duty.
This is
3.
yes.
Paragraph. Under which act, Mr. you are liable to pay electricity duty? Admittedly. What captive generation so and so. Petitioner is a licensee under the provisions of Electricity Duty Act 1939. So you are a licensee under the Electricity Duty Act 1939. The petitioner is a last line in that paragraph only. The petitioner is a licensee under the provisions of Electricity Duty Act 1939, herein after referred to as the Act. A demand notice dated 8/7/2003 was issued to the appellant, by which the appellant was asked to pay a sum of rupees 4,59,85,089. Paragraph. The petitioner, the paragraph, the appellant challenged the aforesaid demand notice in a writ petition. Full stop. The learned single judge, by an order dated whatever date you have just now written, so inter alia held, no, not inter alia, held that issue whether licensee is liable for payment of electricity duty is no longer res integra, as the same has already been adjudicated in a writ petition, namely WP number 8244/1994. opportunity to reflect on your performance. What have you done? What have you argued? Think about it. Before going to sleep, think about it. Was I ready? Was I turning the papers in the court when it was called? Come above COP category and argue. You should have brought Electricity Duty Act with you, right?
Yes, the topic 58.
Which? This. Oh, yes.
This,
Ah, right. Yes, yes. Please. What is it about? No, say everything. You are most welcome to say everything except adjournment. Right.
What is only reason I was seeking adjournment?
No, nothing. No adjournment. No. No. You argue. We will begin. You have to keep us engaged for next 45 minutes. There is no, sorry. Sorry, we will dismiss.
The list was released on Friday, and we have been mentioning to everybody very clearly the purpose of our completing the board earlier during the day is that we take up all the matters. This has been said time and again for last week.
No.
This is the third week we started.
And advance list is published only for this, not for saying that nothing. No, sorry, 18 years we want to test our orders. Let it be tested by Honorable Supreme Court. If in an 18-year-old appeal we refuse adjournment, what happens? Please, if you are expressing your inability, we will dismiss that he has expressed his inability to argue the matter. What's your name? Nothing, sorry. No, does not arise. You start reading.
For next 45 minutes, tell us.
No.
The last matter. What will we do for the next 45 minutes?
No. You start reading the order. Nothing. 18 years. No justification for adjourning a single minute. No. Forget about it, mister. We will write, then you are not arguing despite being told. Third time we have asked you. You are not saying anything that's good enough a ground to dismiss your writ appeal.
Common order.
Where is the order?
Page number 14, to the compilation.
It's not a common order. We want this thing, reasons given.
Convenience compilation.
These are industries seeking the writ of mandamus, demand tariff.
Demand tariff.
Start reading page 23. 23 of this writ appeal A58 of 2005. This one will bunch up to last one. Yes, 220. No, the next one.
So common question is involved in all this petition.
15. This is from item 73 to what, Mr. Which number? 73 to 126. Yes. Yes. Start reading.
Petitioners and all these matters of the industry to file a respective petition.
This thing, mic.
Please use the mic.
The petitioners in all these matters are the industries who file the respective writ petition for the writ of mandamus declaring the action of the respondent 1 and 2 in levying and demanding tariff in respect of power allocated to the third respondent in excess of the bills raised by it as illegal and consequently direct the respondents 1 and 2 to forbear from raising such bills.
The case of the petitioners in brief is that the entire enjoined action on the part of the respondent 1 and 2 in issuing revised bill is purely on an erroneous interpretation of the judgment of the Supreme Court, and therefore the same is wholly unsustainable. It is their case that having regard to various practical difficulties faced in regard to the power supply resulting in power cuts at various points of time, leading to crippling of the industries and hampering the industrial development, the Andhra Pradesh State Electricity Board, along with 6 other companies, entered into an MOU on 17/10/1988, constituting the third respondent for setting up a power generating station. Accordingly, the third respondent was incorporated on 31/10/1988. As per the terms contained therein, the power and energy as generated by the third respondent should be shared amongst the participating industries and also the APSCB in proportion to their paid up capital on a pro rata share of the actual energy generated. Under stage 1, the unutilized energy of the participating in the, it had to be unutilized energy. So,
You have a convenience compilation?
Yes.
What facts have been given?
Yes.
There. Where is it?
Serve the copy.
Give madam convenience compilation.
No. Spiral time machine.
This one, running index. Facts you have mentioned or not mentioned? You have mentioned facts here, not mentioned.
That's one more synopsis also I have submitted.
Where is it? Synopsis.
Based on
It's all madam. You should list. Put a synopsis, like put a flag here so that we know. We don't know. And this all written submissions, etc. are there. Nothing to argue.
Written submissions also on the last weekend. That's
Where is that? No synopsis, right?
Synopsis, the written submissions.
Give a make a photocopy matter of this. So like what you should do is you should flag it, you write here synopsis and list of whatever and written arguments so that we know. Looking at this, you put the flag. We feel that it's order sheet. We don't know. Written submissions also given.
Written submissions are
So your job is very easy. Now nothing left. Go ahead. So what happened 1/7/1988?
Yes, madam. Under stage 1, the unutilized energy of the participating
and 6 others entered into MOU with the Andhra Pradesh, setting up power generation unit.
Shall I continue?
Yes, go ahead with this thing. List of dates you first read. We will get an idea.
Well, it's 1996. Appellant is a HT industrial consumer of the second respondent. Apart from drawing the power from the respondent 1 and 2, petitioner also draws power from third respondent, which is a captive generating power plant. The third respondent, which is an initiative of APSCB, is a public limited company incorporated under Companies Act of 31/10/1988. The said company was formed to set up gas-based power generating station at Videshwaram, West Godavari district, Andhra Pradesh. When the state of Andhra Pradesh was reeling under power crisis, the then APSCB, who was having financial limitations for establishing a power plant, invited public and private partnership for establishing power plants so as to mitigate the shortage of power and assure supply of power during summers. That's on 17/10/1988, MOU was entered into between APSCB and participating industries, contemplated formation of APGTCL for purpose of setting up a natural gas power generating station in the state of AP. The said MOU 1 postulated the modalities of generation of power and supply of the same to the participating industries. As per clause 17A of MOU 1, if the power generated by APGPCL could not be utilized by the participating industries, either in full or in part, then AP Transco and TS Transco shall have first claim to utilize such powers. This was as per MOU 1 minutes. Then 1997, MOU 1 was followed by MOU 2 dated 19/4/1997, which was entered into between APGPCL and APSCB, presently AP Transco and TS Transco, which also recorded the same understanding between the parties thereto. As regards the non-utilization of power by the participating industries, clause 2.8 envisages that when a participant industry for any reason is unable to utilize its full share of energy from APGPCL, it shall give an advance notice of at least 15 days before the billing month to APGPCL Thereupon, APGPCL shall then reallocate the surrendered energy of the participating industry on pro rata basis among those of the rest of the participants who required additional power, and when the advance notice is not received by APGPCL within the stipulated period, the unutilized power shall be fully allocated to AP Transco and TS Transco. 1/9/1999. The third respondent filed an application under Section 16 of AP Electricity Reforms Act 1998 by OP number 6 of 1999, seeking an exemption from the requirement to have a license to undertake supply of electricity to the shareholders, participating industries of APDPCL and their sister concerns. On 25/2000, the third respondent sought permission of APRC to withdraw their application dated 1/9/1999 on the ground that they are not required to obtain license by virtue of sections 26A of Electricity Supply Act. On 7/7/2000, APERC passed an order rejecting APGPCL's permission to withdraw the same, and eventually the APRC has granted exemption from the requirement to have a supply license to facilitate supply of power to participating industries in proportion to the shareholding of APGPCL. The above order dated 7/7/2000 passed in OP 6 of 1999 by APRC was challenged by the third respondent before the Honorable High Court. On 8/6/2001, Honorable High Court has dismissed the appeal of third respondent. The order dated 8/6/2001 passed by the Honorable High Court was challenged before the Honorable Supreme Court. 23/3/2004, Honorable Supreme Court has held that no license is necessary for utilization of energy generated by APGPCL and utilized by the participating industries, and the concerns holding shares of APGPCL transferred to them by the participating industries to the extent of value of the shares so transferred, and it was also held that license for supply of energy to the sister concerns. In May 2004, respondents unilaterally revised the bills claiming right over the unutilized power generated under stage 2. Respondents have raised bills excluding the consumption of power allocated by the third respondents by levying the tariff at its own rate in respect of the power which was allocated to the appellant from unutilized pool as provided in MOU 2. The same was challenged by the participating industries by way of WP number 9154 of 2004 and batch. On 6/12/2004, the Honorable High Court has disposed of the above batch by placing reliance on clause 17 of MOU 1 and holding that the respondent's claim in respect of surplus charges is valid, and the price of such surplus charge has to be determined between AP Transco and APGPCL after notice to the parties. Against the said order, the present batch of writ appeals have been filed by the participating industries as well as the Transco and DISCOMs.
No. Order copy.
Sure. May I read the order, my lords? Order copy. Under stage one, the unutilized energy.
Madam, 2004, volume 10, SSC 511.
On a stage one, the unutilized energy of the participating industries shall be excluded.
Forming part of the
compilation.
You are for the appellants.
Both have filed appeals. Cross appeals have been filed. The department also felt aggrieved by the order of the learned
So
secretary.
you are for the industries or
I am for the appellant and respondent in the appeal filed by the department.
what? Who is the appellant? That's what.
In some we have filed, my lord. Actually, we have submitted a list of.
For the industries or this corporation?
No, my lords. May I give a brief of the outline of the case?
Appearing for the industry or for the corporation?
I am for the corporate. I am for the participating industry. Participate.
Maybe asked because he needs your assistance.
Yes, my lords.
That's why. AP Transco.
Yes, he is appearing for AP Transco, but yes.
No. I am also one of the participating. We are sailing to.
They are appearing for TS Transco.
They are appearing for units.
Let's see. So he is seeking your help. Please help him.
May I, sir?
Yes.
APGPCL is a company incorporated under the Companies Act. Considering the power crisis during 80s, erstwhile APSCB, AP State Electricity Board, along with some of the companies which are power centric, where the power is one of the major raw materials of those industries, they have become shareholders of APGPCL and they have incorporated this company. The MOU entered into between APSCB, erstwhile APSCB, and the APGPCL, that was made as a memorandum and articles of association of APGPCL.
So that memorandum of understanding was on 17/10/88, correct?
Yes, my lord. 17/10/88, page 48 to 58 of the convenience compilation. That MOU was followed by another MOU, which is dated 19/4/1997.
48 to 58.
48 to 58.
Yes. Yes.
MOU 1 has provided for one sort of dispensation whenever there was a supply which has to be distributed among the participating industry proportionate to their shareholding. If one of the shareholders does not utilize their share, as per MOU 1, it shall go to the APSCB. My lords gets that relevant clause at page 55 of MOU 1. Convenience violation.
17A.
17A, my lord. It is agreed that if the power generated by APGs could not be utilized by the participating industry.
1 minute.
My lord, my apologies.
1 minute. Page 55.
Page 55.
Yes.
It is agreed that if the power generated by APGPCL could not be utilized by the participating industries, either in full or in part, then AP Transco or TS Transco shall have the first claim to utilize such power. The price for such surplus energy shall be mutually settled between AP Transco, TS Transco and APGPCL based on fuel cost plus O&M charges plus depreciation, but not exceeding rate for energy as per HT category of AP Transco or TS Transco. It is agreed that as a rule, APGPCL shall not sell power outside the state of Andhra Pradesh and state of Telangana. This was the stage 1 dispensation which was obtaining under the MOU 1. Now, my lords may kindly turn to 66, page 66 of the convenience compilations. Clause 2.6, my lords. My lords, has it? Non-utilization of energy by any of the participating industries to full extent. When a participant industry, for any reason,
is unable to utilize its full share of energy from APGPCL, it shall give an advance notice of at least 15 days before the billing month to APGPCL. APGPCL shall then reallocate the surrendered energy of the participating industry on pro rata basis among those of the rest of the participants who require additional power. However, when the advance notice is not received by APGPCL within the stipulated period mentioned above, the unutilized power shall be fully allocated to AP Transco or TS Transco. Now, entire dispute arose during the currency of MOU 2, wherein the excess power which was not utilized by some of the participating industries was allocated to the other participating industries on their request, which was sought to be charged by the Transco as per the tariff which was prevailing at that time. The contention of the petitioners in the writ petition was that since their right to utilize the power which is not utilized by the other participating industries is guaranteed under 2.6 of the MOU 2, and the charges are paid to APGPCL by the participating industry which is availing that excess power is already paid to APGPCL. No further tariff charges are payable to the Transco. That was the contention in the writ petition. Now, in the order under appeal, the learned single judge proceeded to decide the writ petition based on.
See, let us understand the import of clause 2.6 is that if any participant industry, right, is unable to utilize the full share of the energy,
yes,
then it shall give a 15 days notice.
Yes.
In that case, this APGPCL shall reallocate the surrendered energy on pro rata basis among those participants who want. And if you don't give notice,
yes,
then the unutilized power shall be fully allocated to AP Transco.
Yes, correct.
Right?
Yes, correct.
So now what is the dispute? The dispute arises from 2.6.
2.6.
What is the dispute? 1 minute.
So they give information, 15 days advance information. Therefore, they can modify to other members. But let us say today I'm getting 100 kilowatt. I'm forgetting, but I'm not utilizing for some reason. My sales having very fit. So the as for the area plus 17A, first priority will go to transfer. So that because the grid will also to the grid from grid. So they grid will utilize, transfer will utilize. It is this situation is contemplated only when 15 days advance notice is given that I am shutting down, therefore they can allow. Without such notice, if anybody doesn't reply, then the right should go to them. So, and that's from that, if anybody is drawing more power, they are charging him as per the rate. This is the dispute which they don't want.
Yes.
So, my lords,
what according to you is the dispute between the parties?
My apologies.
What is the dispute now between the parties? We want to hear you.
My lords, the dispute is the power which was not utilized by the participating industries, some of the participating industries, has been supplied to the other participating industries who opted to take the power.
In case where you have given notice.
Those records,
case only where you have given notice. Where you don't give notice.
Those records are not before, my lords.
See,
this clause itself
2.6, if you are relying
Yes,
on 2.6, what my lord is saying is only that situation would arise only if you have given a notice that due to certain breakdown or due to scheduled maintenance, your plant will be closed. Therefore, you will not be able to utilize the power which you are entitled to under the agreement.
Yes.
That power, they can allocate it to others.
Yes.
But let us say I am getting 100 kilowatt. I am entitled to get 100 kilowatt. For whatever reason, I am unable to utilize 100 kilowatt. I am only able to utilize 50 kilowatt.
Yes.
Remaining 50 kilowatt shall go to first right of utilization will be to the Transco. That is what you have to read both 2.6 and 17A together.
No, that in my submission, the purport is the two different dispensations. Under MOU one shall go completely, whoever, no, whichever industry does not utilize it, it shall directly go to Transco only.
In fact,
No other.
go to page 48 and read the heading.
Yes.
This doesn't contemplate the 15 days break.
Please read the memorandum and articles of association, then read including memorandum of understanding 1 and 2. It is not as if one came after the other. By the date of your memorandum and articles of association, you have this MOU, both 1 and 2 together. That's why both have to be read together.
This thing only says that it will have first right, which is clarified here by allocated to this, and the price is this thing with on the basis of Transco and APGCL based on the fuel cost and all.
That is cost.
So, Mr. According to us, subject to what you argue, when you have to put forth clause 17.A and 2.6 have to be read together, and they are not in conflict with each other. They can be harmoniously read, right?
Yes, sir.
So, intention of full effect shall be given to the intention of the parties by the court, and clauses in the agreement have to be read harmoniously, and there's nothing contradictory, right? Same thing, that in case you are unable to utilize the power generated by APGPCL, the APGPCL shall have, the Transco shall have the first right. Same thing, it later part, unutilized power shall be fully allocated to Transco. So, in addition, to clause 2.6, it says that Transco shall have the first right for allocation, and it should be fully allocated to Transco. Right? And this 2.6 is sort of clarificatory in nature, saying that in case you give 15 days notice, then it can generate, it can distribute the power amongst the participants who want to utilize it.
Yes.
Where you don't give notice, then it only goes to Transco.
Yes.
And 17A provides that Transco shall have the first option to utilize, first right to utilize the power which is not availed by you.
No, in this, the issue in controversy in the writ petitions is the participating industries have utilized the power which was not utilized by the other industries. In fact, Transco is not claiming that power shall go to them. The
participating industries have utilized the excess power.
The participating industries have utilized, the other participating industries have utilized the power which is not utilized by the other party.
The appellants before us, appellants industries before us have utilized the excess power, correct?
Of the other participants which have not been utilized by.
So then what is the dispute then?
The dispute is they have the over and above the charges which I have paid to APGPCL for utilizing that excess power. The Transco also wants to levy tariff on me. In fact, the bills which were raised by Transco at the relevant point in time were challenged by us in the writ petitions.
So what is, Mr. Where is the mechanism for determination of that this thing? Excess power of this thing, reallocation of surrendered energy which is utilized by other industries. Where is that provision for determination of that tariff or cost price?
That periodically the demanded tariff rate will be notified. So the additional power which has been taken will come under demanded tariff. This will not be there. There will be the general tariff.
That's what. So what is it, Mr. Tell us.
Demanded tariff would be regular tariff order.
Yes, sir. Here, 17A, my lord, that price, if your lordship, I'll just read 17A. We agreed that if the power generated by APGPCL could not be utilized by the participating industries, either in full or in part,
then AP Transco, operating TS Transco shall have the first PM to utilize such power. If the price for such surplus energy shall be mutually settled between AP Transco TS and APGPCL based on fuel cost plus operation and maintenance charges plus depreciation, but not exceeding rate for energy as per HK category 1 AP.
No, that is
This is
between,
what we have to pay to APGPCL. This, see, my lord, that extra power which we are utilizing, which because they have not, our my lord, if this that has to be arrived at only that in between APGPCL and us, not we are
so
utilizing
same you will recover from the participating industry.
as per the tariff orders issued by ERs, electricity directory.
Fine.
That is the thing.
What is the dispute, mister? Then you
Now-
still you have to tell us.
No, madam. The over and above the charges which I have paid for the power which I have drawn from APGPCL, which has not been utilized by the other participating industries. The Transco also wanted to levy charges on me as per the regular tariff, which has been challenged by us in the writ petitions. Now, in the learned single judge, proceeded to dispose of the writ petitions, directing APGPCL and the participating industries and Transco to hold mutual discussions and arrive at the price, which is as per clause 17A of the MOU 1. So the learned single judge proceeded to dispose of the writ petition only relying on clause 17A of the MOU 1, completely disregarding clause 2.6 of the MOU 2. That is the grievance of the appellants in the writ appeals filed by the appellants.
No. So even if clause 2.6 is taken into account, it does not deal with this thing fixation of tariff or cost. So even if it is read, Mister, you have paid to APGPCL.
Yes, my lord.
APGPCL, you have paid the cost of whatever cost or tariff in respect of extra power which you have consumed, right?
Yes, my lord.
So now, Transco under which provision wants to levy tariff? You have to argue, Mister.
As per the tariff orders, my lords. In fact,
So what is wrong with tariff order?
Our submission is
1 minute.
My lord, my apologies.
So they have agreed at a rate. It is so that I am just giving which APGPCL will charge.
There is a level price between APGPCL and
the actual users.
Transco.
No, actual users. This is only meant for actual users. Then what happens? Let us say today I am entitled for 100 units. But if I am using more, 150 avenue this plus 50 avenue plus. So they have paid agreed rate. But as per the clause, we will 3.6. If it is not coming within 15 days, I will have to pay for the difference of 50 at the tariff rate, which is fixed by.
Doesn't say.
No, that is at 17 years. It shall be tariff.
Nice.
Exceeding rate of energy as per HT category. That is tariff rate which is notified by the regulatory commission or the board.
No, sir. See,
this is the under limit. Outer limit is not
such surplus means such surplus power energy shall be made available to Transco.
Yes.
Shall be mutually settled between Transco and APGPCL.
Based on fuel costs. It is between them, not between the actual user.
So then how it will bind him?
No. Then the agreement what they have entered with APGPCL for purchase and reduction in their consumption. That provide that if they demand anything, they take more unit from the grid. They will pay for that at the rates as per the category. That Mr. Vinod,
tariff order.
Tariff. This agreement, you see, in APGPCL, when all these units have entered into agreement with APGPCL to take particular load,
They have reduced their minimum this thing from electricity board.
Yes.
Correct? So in that agreement, there is a clause which says that in excess, by any chance, if they take more from the grid, the difference, they would pay the rate at the rate as per the tariff order. That is what I remember in these the power private company power PPAs. These are all under power purchase agreement. They agreed at a rate. Let us assume 10 rupees per unit is the rate which they have agreed to supply, take it from APGPCL, whereas your tariff rate is 20. As against 100, they take 150 from the grid. So the difference 50, you will bill them at tariff card, your rate. That is what. And similarly, that 100 is my sanctioned load, but I don't utilize due to plant breakdown or maintenance or whatever it is. I am unable to use and I do not give that 15 days advance intimation. It is going in the grid. If whichever unit is taking more, I will charge them at my rate. I will not give them the benefit of this
APGPCL power.
agreed rate. This is the case.
Where is that agreement between the private companies and
It's a tripartite agreement, no?
MOU 1 and MOU 2 are the agreement.
are they signatories? The industries are signatories to that MOU.
Yes, yes.
So which clause they have agreed that they will pay tariff as per tariff order?
Well, at that
And you have levied, Mr. They have levied tariff in accordance with the tariff order,
Yes, my lord.
right?
Yes.
Is there any agreement between you?
Normal.
That's what you used to point out.
My
That's your grievance.
That's my grievance.
Just a minute. So your grievance is
That is my grievance.
in respect of extra energy consumed by you, right?
From APGPCL.
So you have, since you have paid the amount to the
APGPCL.
APGPCL, therefore you are not liable to pay any amount under the tariff order.
Yes, my lord.
Correct?
Crux.
So which, Mr. Tell us now, that's the crux.
No, my lord's my kind.
1 minute, 1 minute. We will note
My
down
lord.
the crux.
No, if my lord,
Because we will
if I can take my lord through
Just a
the
minute.
judgment of the learned single judge.
Just 1 minute. 1 minute, don't confuse.
My
The issue is whether appellants, just 1 minute, we are noting down. We are not dictating order. We have to hear you here. We are trying to, the appellant industries are liable to pay tariff to Transco. Liable to pay tariff to
Transco.
Transco under the tariff order.
Yes.
On account of excess electricity consumed by them.
Which is unutilized by the other participating units.
Excess electricity on account of unutilized electricity consumed by the appellants, right? As industries, as you have paid the cost, right?
Yes.
You have paid the price for surplus energy.
Yes.
Surplus energy to APGPCL. Correct?
Yes, ma'am.
CL, no agreement to pay under tariff order in respect of excess electricity, right? Correct. This is what it is.
That is the crux of the.
And what the
Issue in
learned
part.
single judge has done. Learned single judge has said that all of you should sit together and decide.
That is as per clause 17A.
It can't be 17A, right?
My lords, may I take my lord?
No. Your submission is can't be 17A
Yes,
because
sir. My
17A does
submission-
not involve you.
Yes, sir. My submission is I am
The
covered.
third submission is direction by learned single judge. No, learned single judge should have appreciated that 17A does not apply to industries.
Yes, my lords. Because that clause
It is,
4.6.
Mr. It is APGPCL and Transco, not you.
No, I am also shareholder of APGPC.
The lordship may take page 51. It's signed by all the parties, the agreements, even they have signed.
51.
51.
No, Mr. But see, one thing, I mean, you said that they have entered into an agreement to pay in respect of surplus energy as per regular tariff order. He says there is no agreement. Please point out where is the agreement.
In that agreement to that extent of whatever power that is in excess, it is not for the agreement, we are entitled. Once it is entitled to, it is our power. And only as per the tariff orders only we can collect. We cannot collect less than that. That is the
First of all, there should be clarity on facts. Is there any agreement saying that in respect of excess electricity supplied to these unutilized energy, surplus energy supplied to these industries, they shall pay. In addition to, just a minute, please listen. They shall pay the price of surplus energy to this thing, APGPCL, and in addition shall pay tariff under the regular tariff order to Transco.
yes, right. Issue is right. True aspect.
Right.
Under
This is it, right?
Yes.
This is the controversy, right?
Under the MOU 1 then MOU 2 is signed by both the parties. And one thing, may I suspect?
So which clause of the MOU says that they have to pay regular tariff under the regular tariff?
It doesn't say regular tariff, it says the power. If you allow even 17A, what it says, if it is agreed that the power generated by APC could not be utilized or participating either in full or in part, then AP Transport shall have the first claim to utilize. We have the first claim, we have claimed.
No, see, this liability to pay this amount, Transco, 1 minute. You don't know what we are trying to say. So, a liability to pay this amount under the agreement can be to pay the amount can be under an agreement or by virtue of any statutory provision also. So, don't confine yourself to this clause and that clause.
Yes.
It can be under a statutory provision also. Tariff, they may be liable to pay under a statutory provision also, not necessarily under agreement. Get it? So, this 17A does not say it pertains to price for such surplus energy mutually settled between Transco and APGPCL on fuel cost plus O&M charges plus depreciation not exceeding. It doesn't say that this cost price shall also, I mean, there's no dispute about this price, right? They are only saying that we are not, since we have paid this price, as we understand, and correct us. His case is that we have paid this price to APGPCL. In addition, now we are not liable to pay any tariff to Transco in respect of this excess power, surplus power.
The correct.
Yes.
The first part of the section, 17A, any power which is not utilized belongs to Transco.
Under either it has to be under a statutory program or agreement. I've explained it. Please tell.
See, the collection, their case is that they have paid to APGPCL, even for that excess power consumed by them. Now you are saying for that excess power, the AP Transco is entitled to recover that amount as per the tariff order. Now, if it is as per the tariff order, then something should be shown from your agreement that such power is vested, that they are not entitled to draw excess power than what they are entitled under the agreement. Beyond that, you obviously it has to be only through the your source is should be your case. So you will have to show us whether under the agreement there is such a restriction that they cannot draw excess power from even if it is available, unless until that 2.6 clause is invoked, where 15 days advance intimation is given, where necessary arrangements are made by the local this thing for monitoring, measuring what is the power they have drawn from APGPSL that excess. Then otherwise it should be only to be treated as supplied by the transco, for which you are entitled to billing. Either it should flow from the agreement or by way of a statutory enforcement. These are the 2 points.
Yes. These are the points, my lord, the lordship point. Here, my lord, APGPCL, my lord, this notice, 15 days notice has to be given by them to APGPL, saying that I don't need this power.
That is where you can make arrangement. That is where you can make arrangement to measure that 15 days period.
Yes. We have asked them, man, to provide the details because letter is given to them by the other participating industries who do not require this power to please give all the details who have given to that 15 days notice so that it can be allotted by APGPL some other industry if they require only. They also say I require this power. If not, my lord, in the excess is all belongs to us, which we are entitled to claim from these industries based on the tariff orders. That's our case. And one more thing is one difference we have taken in this.
What they are likely to pay. So in this agreement it is that not so. Two members of APT. Each 52, each 52. What I will check that. With this book for. I will mark. I learned classes because I remember doing this. That is why I am aware of this business transaction, how it is done.
My lord,
No, right to share of energy. So AP transfer. And AP transfer shall have the right to sell share of energy and power to its consumers who may include. So they are entitled to sell the between applicants who are members of APG. Correct. But what will be this? The tariff in addition to what we agreed that will so, Mr. You have to tell us as we are telling you, think about it again. What is the provision under which they are liable to pay tariff to transport? That provision can be either under the agreement or under a statutory provision. This is the only issue. Correct?
Yes,
whatever facts, whatever it is, the issue is they are questioning your this thing action of transpo in demanding tariff in respect of surplus energy. So where is it? Again, third time I have told my brother has told. I am reiterating.
I satisfy your lordship, my lord. Statutory
Point out. Yes. Tomorrow. List on account of for the appellants commenced their submissions. However, on account of paucity of time, same could not be concluded. This thing, admission directions and all. Final hearing, it will be top of the list. So, young man, happy at the end of the day. Happy at the end of the day, your prayer is granted tomorrow. You should be. No day after. This is Mr. 18. This, we have refused the prayer for adjournment to this. What's your name? Mr. Shreyas. So, and we have commenced the hearing. No, that's 18 years. So you must, you come for his rescue at the right point of time. Mr. Counsel.
Comrade.
Yes, correct. By instinct, you knew that my colleague is in difficulty. You rushed for his help.
Deeply obliged.
Like a wind. Yes. That's it.